My name is Stephanie Harrison Casey. I'm the head of chambers at Garden Court, and I was one of those who was in many ways privileged and fortunate to take part in the Brook House inquiry. Privileged and fortunate not because of the subject matter, which, as I'm sure you all know, was extremely distressing, shocking and outrageous, but because it allowed me to take part in a legal process with colleagues, many of whom are going to be speaking today, that did shine a light on the darkest corners of our state activity. Vulnerable people in immigration detention, to lift a lid on the abuse. And for the first time in the context of a statutory public inquiry, hear evidence from a wide range of individuals, from individual officers right up to senior Home Office officials, as well as from, of course, at the heart of it, the former detained people who had been subject not only to mistreatment, abuse, but a regime in immigration detention that quite properly and only can be described as inhumane. Being able to be part of that process that has resulted in the publication of the 3 volumes of the Brook House inquiry, for me, was the end of a long road of working with many others in trying to expose, and in many ways failing to expose, the true extent of the mistreatment and abuse that was taking place at Brook House and across the detention estate. It only really became exposed as it happened previously because there were undercover reporting. And so I do want to also mark and pay tribute to the courage of Callum Tully, who was the BBC journalist, who, without his willingness to stand up and say this has got to stop and this is not acceptable and it needs to be brought to light, we wouldn't be here today. And so we had thought that it was very important. This conference is hosted by Garden Court Chambers, but this is a joint effort. They're not responsible for the technology. We take our responsibility, but for everybody else who's going to speak with you, you have representatives from the Brook House inquiry legal team, both barristers who represented core participants who were formerly detained persons, and to charities, NGOs, Medical Justice, and the Gatwick Detainee Welfare Group, who were core participants as well, although other NGOs, many of whom are in the room, BID, Detention Action, also gave evidence, and they were assisted and represented by 3 legal teams instructed by Duncan Lewis, Bat Murphy and DPG. And you'll hear from all of those lawyers, but you'll also be able to hear from experts who gave testimony to the inquiry, from Dr. Rachel Bingham, who is a medical practitioner at Medical Justice, Dr. Brodie Patterson, who gave an expert report on use of force and mental health conditions. And also at the end of the evening, I know it's going to be a long day and we're going to have to speed up and get some time, but I hope that you'll be able to stay for the end, which will be a session with Professor Mary Bosworth, who is at the Oxford Institute for Criminology, who is going to discuss some issues of institutional culture. So we're going to look at the whole spectrum of the key issues that were before the inquiry. That is centrally and crucially starting at beginning from Article 3, and what that important obligation under the ECHR provides to us in terms of a legal framework in which the inquiry did its work. Also looking at detention safeguards and their failure, the use of force, misuse of force and segregation, and ending with institutional culture, which in many ways is where we start, because it's in that context that abuse and mistreatment was so widespread within Brook House. So what is our purpose? The heading of the sessions are what lessons have been learned. And we can be pretty certain, and it was absolutely apparent from the findings of the Brook House inquiry, that no lessons at all had been learned from 2017 and the broadcasting of the Panorama programme. The importance of the inquiry is that it was not historic. It was not looking at a snapshot in time in 2017 where everything had been resolved. Absolutely not. It was up to the minute. The last sessions were heard in April of 2023, but there were later submissions made to the inquiry. Right up until the reporting in September 2023, the structural systemic failures were in place. And all of the conditions that had led to such extreme abuse in 2017 were well and truly still operating at Brook House and elsewhere. The state has not yet learned lessons. We can have no confidence that it will. The inquiry has written, chair has written to the Home Secretary asking for an update, and there's deafening silence on updates on recommendations. So we thought it very important that those who work in the field on both sides, because there are individuals who work for the government legal department, and obviously many lawyers and campaigners and practitioners in the room and online, whose daily work involves questions of detention, lawfulness of detention, treatment of individuals within detention, that whatever else happens, we must learn the lessons of the Brook House inquiry. And it does have resonance and acute relevance to all current cases of detention, whether they are ones that you're dealing with historically in the sense that they're ongoing claims, but also current claims and future claims. Because what we do know is that there is no prospect that the state is going to act swiftly to take the remedial steps in the recommendations that the inquiry made. There are 33 of them. Instead, we know that at the same time as the Brook House inquiry was collecting its evidence, the government embarked on a marked change in detention policy, even from where it had been prior to 2020, to deliberately decide to expand the use of immigration detention, to introduce quasi forms of detention in military bases and elsewhere, and obviously commit itself to an even more deeply hostile policy for the treatment of asylum seekers and refugees. And so we can certainly say if the Illegal Migration Act 2023 comes into force, and it's looking like it will imminently, then there is every need for everybody who is engaged in this sector to be fully cognizant and to read and to understand and to learn the lessons from the findings and evidence that was in the Brook House inquiry. We have made sure that you have access to it online. So links will have been sent along with other useful material. The Medical Justice did a briefing which summarises the report, and that's a good place to start if you want to get to grips with some of the detail. Obviously, going forward from today, you'll have seen the highlights on where it is that it can have direct impact on your current practice. And we'll send out further links later to other relevant material. We're very fortunate that, in fact, Medical Justice have also just about to publish a new report using one of the most frightening phrases that were repeated in the evidence in the inquiry: if he dies, he dies, signifying the extent to which there was complete disregard for the humanity of and the welfare of the people who were being cared for within detention. And so the resources are there. I hope when you go forward from today that you keep whatever copy of the Brook House inquiry you have, whether it's online or in hard copy. I've got mine here, got my yellow stickies in it because I use it on a regular basis. You will see at the end of these sessions how critically important it is as a tool for challenging unlawful detention, misuse of power and abuse within ongoing claims. I wanted to just say from the outset is I am going to show you some of the footage, and I'm going to do that not, I hope, gratuitously, because it is distressing, but to illustrate why it is and why we have to act with urgency to ensure that the material in the inquiry is disseminated widely, whether that is through meetings such as these, training, and also obviously in your legal cases. Judges need to see that this is a system that they also have presided over for the last 10 years. And whilst there have been some important recognitions of the unlawful detention practices that are taking place, including on a systemic level, and findings of an Article 3 breach, the legal system needs to recognise that it also failed in seeking to ensure that measures were in place to prevent the kind of abuse that was exposed in Brook House. And so before we go on to the first session, I'm going to show you two clips. One I'm going to keep short because it's the evidence of the most serious form of abuse that took place and that was shown by Panorama, and the second was only uncovered as a result of the footage that was obtained by the inquiry.
Watch this. Most distressing treatment taking procedure at the time. Stop it. Stop. Stop it. Inside. Inside. He's trying to strangle himself with his hand. Stuff because fingers it's just neck, it's she just sort of hold on and I said, yeah, easy. After the violence. This is what it's I see.
So that was the footage that was broadcast in September 2017. The minister described it as appalling. It obviously is, and it illustrates some of the extreme consequences of a system that fails to ensure that the welfare of the person is at its heart. That was what was shown, and I'm going to show you one more piece of footage, which was only, as I said, disclosed as a result of the inquiry itself. So that footage is not an incident of somebody attempting to strangle and threatening to kill. That incident is what is happening every single day, probably, in removal centres, because that is removal. That's what deportation and removal means. And the shocking thing about this is that the man was naked, not because he was protesting or anything like that, but because of the no notice removals policy. So if you recall, that policy was declared to be unlawful in 2020 because it resulted in unfairness. It didn't allow people to get access to court. What we could never have known is that it also had that implication. So people being taken from the removal centre from their beds in the middle of the night or in the morning. That's why the man was naked. And obviously what it also shows is that he was seriously mentally ill, but nevertheless he was being removed from the United Kingdom. And what it was using with all of those officers, there's about 5 or 6 of them, all in full PPE. The inquiry said was unacceptable and shouldn't be occurring. And they were using techniques that were plainly unlawful. Not only were they unlawful, they were techniques that had been declared to be such because they're the same techniques that contributed to the death of James Mabenga. And elsewhere in the system in 2015, they had been outlawed. You couldn't do it. But in Brook House, it was still happening in 2017. That is one of the 19 incidents of inhuman and degrading treatment that the inquiry found. And in some respects, it's the most significant because this is routine. This is what removal means. And so it's in that context, and I apologise that it is so distressing, but I think we do have to remind ourselves that this is what we're dealing with. This is the end result of the detention policy and practice that we're looking at, and why Article 3 mistreatment needs to be at the forefront of our analysis and our challenges to current practices. So with that in mind, I'm going to hand over to Emma to deal with the first section, which is first sessions dealing with Article 3 mistreatment.
Thank you, Stephanie. My name is Emma from Medical Justice, and we are the organisation that brought that challenge against the no notice removals policy, which we were successful in. Medical Justice was granted core participant status in the Brook House inquiry due to our expertise in failures of healthcare and clinical safeguards in detention. What makes us experts is that we are the only organisation that routinely sends independent doctors in to see detained clients and document their deterioration of health in detention. We're so grateful to have been represented by Hamish from Bat Murphy, Stephanie, Kushin and Laura Profuma, which we're unspeakably grateful. We've only been gathering our evidence really for the last 18 years since we were founded in 2005. And what we particularly wanted to be identified through this inquiry was the fact, a recognition of the fact that medical mistreatment in detention is endemic, the extent of the harm, the severity of the harm, and the fact that it leaves people vulnerable to other forms of mistreatment, like the scene that we've just seen that Stephanie showed. And I think that was achieved. I want to be so bold as to claim a slice of success in the inquiry, in that Medical Justice, in the amount of evidence that we brought, not to mention the amazing oral evidence that Teresa Schleicher and Dr. Rachel Brigham delivered. It is a great step forward in getting such an undisputed understanding of the nature of abuse in detention. It was extremely disheartening the week before last that my colleague Ariel and Idel organised a meeting with the Home Office where they said that they claimed that we're in a different place now than we were in 2017, which is obviously not the case. Alex described to me that this is a long march, which is true. And that's why this seminar is so important, and we're so glad to be a part of it. I'm here with my colleagues Idel and Ariel, who've just produced this report. if he dies, he dies. This is all about evidence of harm of 66 detainees that have happened since the inquiry. So it's still ongoing, and still the lessons are not being learned. I'm also here with Elspeth, who runs the all-party parliamentary group on immigration detention, who had a briefing with Kate Eves just last week, and also Dr. Rachel Bingham, who you'll be hearing later, and also Angela Burnett. And in this section, we're going to have the first three speakers dealing with the three different aspects of Article 3. First up will be Alex Goodman, and Mark Chambers. Alex has also been involved in medical justice all the way back since 2005, because he was a founding member, and indeed he was the first chair of medical justice. Alex represented a number of detained people, including D1527. Alex is going to take us through how the case law tells us that, for example, it's not simply enough to make sure that guards don't beat people up, that there needs to be a framework of policies to protect against that happening, and about the need to identify failures as a system as a whole, as distinct to individuals' conduct. He's also going to tell us, describe, I think, a progression through the course of the inquiry of seeing things as a series of incidences to developing a more understanding about the systemic failures. Then we're going to be hearing from Alex Shimmick, who also represented core participants in the inquiry. Alex is a public law and human rights barrister specialising in immigration detention. He frequently acts in judicial review and civil claims relating to detention, and has written about immigration detention in Public Law, the Journal of Immigration, Nationality and Asylum Law, and on the UK Constitutional Law Association blog. Prior to coming to the bar, Alex worked as a judicial assistant to Lord Justice Singh and as a caseworker preparing unlawful detention claims, including that brought by D1527. Alex is going to give us an overview of the background of the inquiry, such as the terms of reference and the MA and BB judgment. He's also going to give us a short summary of individual instances to give us some form of context, and he's going to end with conclusions that will be maybe helpful pointers for challenging civil claims. Finally, we're going to hear from Gordon Lee. Gordon was a member of the team representing core participants who were detained and had particular responsibility for D643, whose case he will highlight. Gordon will touch on barriers to IRC doctors getting access to meaningful healthcare and failure of dealing with diagnosing people with PTSD. He's going to set out what happened in law, and we're going to hear later from Dr. Rachel Bingham what she actually sees on the ground. But Gordon's going to illustrate one case to highlight those. Thank you.
Thanks for the introduction, Emma. Hello, I'm Alex Goodman. I'm going to talk about the Article 3 systems duty. So I'll just start, I'm going to mix it in with a bit of explanation of how we to where we are today in the history of this case. I was instructed, first of all, back in May 2017, as it happened by Speaker Sane Duncan Lewis, who was assisted at that time by Alex Shimmick, who was the principal paralegal working with him at the time. And the instructions were quite straightforward, simply, we think there's an unlawful detention, this man seems to be suffering, can we try and bring a judicial review claim? As we looked in more detail, it became clear that the client was in severe distress and was suffering considerably. We issued a claim for judicial review, and at that time he wasn't able to articulate the full extent of what had happened to him. This is the client who you've just seen the video about. But even on the available information, it did seem to us that it was reaching a level of inhuman and degrading treatment, the suffering he was enduring. And so we pleaded that in the claim form without any of the knowledge of what came out of panorama and so on, but even just the sense from his own instructions was that it was reaching those kinds of levels because he was mentally ill, he was self-harming, he was attempting suicide almost daily. We managed to get a doctor in to see him to get some evidence of all of this. Thankfully, we got him out of detention a couple of weeks later. So I think we will still be in an even worse scenario there by that intervention. I mean, that was an interim hearing in open court, resisted by the Home Office in spite of what we now know the way he was being treated. So that was May 2017. Panorama wasn't shown until September. Just to give you some of the background to this, by the point at which we were pleading the Article 3 breach, saying he was subjected to inhuman and degrading treatment, there had been 5 cases in which the High Court had found that immigration detention had resulted in breaches of people's Article 3 rights, and I've listed those there. And they're all in the paper. I hope everyone's got a hard copy. For those who are watching this later on video, it will be emailed to you as well. So you don't need to write all the case references down and so on. You've got them later on. So there've been 5 cases already in which there had been said to be Article 3 breaches. There have now been 2 further cases, VC, which the reported judgment's Court of Appeal, but it was settled in the Supreme Court on the basis of concession of an Article 3 breach and a further High Court judgment. The government, responding to those 5 cases, had decided to appoint Stephen Shaw to conduct an investigation into the findings, and he produced a report in 2016. And in that report, he asked Jeremy Johnson, QC as he was, now Mr. Justice Johnson, to review the case law. And he summarised this. It's all in Mr. Shaw's report. There's hyperlinks in the electronic version of my paper to all of these. And key findings within that summary from Mr. Johnson include that the nature and pattern of the findings tend to suggest that these cases may be symptomatic of underlying systemic failings and a reflection of a systemic problem. So Mr. Shaw in 2016, before all of these events, already identifying that these were not one-offs, these were not just bad apples or aberrations. This was symptomatic of a systemic failing within immigration detention. So all of the events that occurred in 2017 that were the subject of the Brook House inquiry had been prefigured by this warning by the person who'd been appointed by the government to tell them what was going wrong. And not only that one report highlighted that, there had been, and you've got this in the paper, catalogue of cases going back to at least 2006. So if you look in my written paper here, put it on the slides because it's too extensive, but there's a chronology there. Now, this is not all the cases. These are just some of the most relevant cases that I've selected that might have prompted a conscientious minister to think there's something coming out of this litigation. Now, the litigation is only about a fraction of the cases that get representatives. And those who get representatives are a fraction of the people who are named. And the cases that actually get decided by the High Court are a very small fraction of the overall picture. But if you're getting a repeated picture from cases that actually get fought by the Home Office of these kinds of issues recurring, one response might be for a responsible government to try and understand what the underlying systemic problems were. And so just to highlight a few of them very quickly, because we haven't got a lot of time, but you've got a list here to give the more detailed chronology. 2006, what's now called HK Turkey, was originally called DNK, was Stephanie Brook, a junior led by Linda Singh. That really highlighted what by then had already become serious failings in the system of Rule 34 and 35. So Rule 34 of the detention centre rules says within 24 hours of being detained, a person must have a physical and mental medical examination. Sent. Rule 35 then requires a report to be sent by the GP to the manager of the detention centre and then on to the Secretary of State in respect of anybody who may be suffering, anyone who may have suicidal intentions, or anyone who may have been a victim of torture. And so the idea behind these rules was to screen out people very quickly upon being detained. So the government originally said, reject the suggestions of NGOs that we should screen before, but we'll make sure they get out as soon as they're there. So within 24 hours, screened. What the judges have interpreted that to mean is that within a further 24 hours, anybody who shouldn't have been detained because they are vulnerable, reason of mental illness or suicide or history of torture, etc., should be released within a further 24 hours. That was what came to the court in D&K in 2006. Mr. Justice Davis said the Secretary of State's conduct was not a rare and regrettable lapse in the circumstances of these two cases. Rather, it reflected the cross-the-board failure to give effect to the requirements of Rule 34 and the applicable standards regarding compliance, neither necessary or appropriate. I repeat what I said earlier, this is not acceptable. He credited the Secretary of State with a disinclination to abide by statutory rules. Now, so clearly in 2006, there was already a position where a conservative High Court judge was willing to say there'd been those kind of consistent failures. Those words could describe precisely the position that we advanced successfully and was accepted by the chair of the Brook House inquiry 15 years later. Moving on to 2008, you can see in the list, case of B, that was one of my cases. That's another case where the High Court said B never have been detained, but she should have been released within 48 hours, given the vulnerability she presented with. She was detained for 6 months. So that's 2008. Then I've got a whole load of cases from 2009, 2010. If you go down to a case called Nooker Jams, a case I did about a family who were being detained, again, in breach of all the practices designed to protect children from inappropriate detention. Then you can see a case below that called Raki, man detained for almost 5 years in circumstances he couldn't be removed. Then you've got Kambadze and Lumba. They went to the Supreme Court because the Home Office had been operating secret and unpublished policies that were unlawful about detaining everybody on a blanket basis without exercising any discretion. Anyone who committed a crime was detained. So there are multiple forms of unlawful conduct throughout this period. And then through the chronology, you start getting then to the consequence of all of this unlawfulness starts to be reflected in the Article 3 cases. The first of them is the case of S in 2011. And through the chronology, you'll see other cases like detention action, failures in the fast track processes in 2015. 2017, the medical justice case was all about attempts to water down the policy so as to make it easier in effect to detain vulnerable people. I won't go over all of it because it's too extensive for my 15-minute slot, but it's there for you just to give you a flavour of what might have been done if anyone had been concerned to look. So I'm going to get onto the Article 3 duty. Here's a summary. There's 3 components, not an official summary, but it's often used as a way of understanding it. So the basic Article 3, no one shall be subjected to torture or to inhuman degrading treatment or punishment. The basic prohibition: don't torture people, don't degrade them, don't subject them to inhuman treatment. So that's the substantive negative duty. But the case law from the European Court of Human Rights and domestically has always said that implicit within that, in order to make that effective prohibition, are what you might say are positive or procedural duties that flow from that basic negative prohibition. One of those is to put in place a suitable framework of laws and policies to make sure that those abuses don't happen. And one is to make sure that where an abuse has occurred, that is investigated. So I've set out here the duty not to mistreat. That's what Alex Schimmett's going to be talking about, I think, so I won't go into that too much detail. The investigative duty was very important because that's what we relied on. Once we'd then seen the panorama footage, came here to Garden Court, and we had a conference with Stephanie, who immediately said, this is a question that arises from the investigative Article 3 duty, where we can see credible evidence of this kind of abuse taking place. There has to be an investigation. We sent a letter to the Home Office saying this. The Home Office contested it and said, no, there's plenty of other ways in which this is going to be examined. There's going to be prosecutions, there's going to be civil claims, there's going to be Home Office Select Committee inquiries. There'll be an inquiry by the Home Office's own professional standards unit and so on. We said, no, you need a dedicated inquiry, and ultimately Mr. Justice May agreed that there had to be a public hearing, to be funding for witnesses to participate. There had to be an ability to compel people who would otherwise proved useful in the context of the inquiry to give evidence, and to be subjected face to face with the victims if they so wished, to confront them and see them. And then we get to the systems duty. So this is the duty to put a framework in place to make sure these things don't happen. So that's the key to where we're at now, because what we know from the inquiry and what we know from this history of litigation is that these problems are occurring over many, many years. The inquiry ultimately found 19 incidents from a very small sample that took 13 cases in detail. 3,000 people were detained over that period. Most of them couldn't be found or located to give evidence, but the inquiry looked at 13 of them. Of those 13 individuals, it found that there were 19 incidents which amounted to breaches of the 3 prohibition of inhuman degrading treatment. We know that there's this systemic problem causing that. The whole case for us was the reason these things are happening is that people are not being filtered out by Rule 34, 35. You're getting very vulnerable, mentally ill people. Put that together with a failure to put in place processes to restrain the kinds of abuse that we've seen. So where we're at now is how do we give effect to this duty under Article 3 to put in place systems? The government has always said that's its intention. You've got the Lord Filkin statement from when immigration detention was first hugely expanded under the Labour government in the early 2000s. It was always the intention that vulnerable people filtered out. It just hasn't been given effect. I've summarised some of the chair's findings, serious failings, and I won't go through them for time, but you've got them all there. They are, in summary, findings of system-wide failures. Completely rejected the case for Serco and for the Home Office that this was a series of bad apples, a series of one-offs, and said that there are serious flaws in the system as a whole. And she made 33 recommendations, but the 2 key ones, I would say, are that if we limit detention to 28 days, then many of the worst abuses would be obviated, and the operation of Rule 35, that's the reporting on vulnerable people obligation, needs to be reviewed and audited regularly. So how do we make it work now? Primarily, this needs to turn to the political sphere, because Home Office and those who can put pressure on them need to reform this system. We can't simply keep bringing cases, keep bringing inquiries, keep exposing continual. It's tragic to hear the Home Office thinks they're in a different place already, having not implemented any of the recommendations, having heard evidence very recently of the continuing nature of the problems. As a fallback, there is a continuing Article 3 obligation. It continues to exert some force in a legal way because of this framework duty, the obligation to prevent a further breach. So there is scope for further legal action if we have to. It's all my time, I'm afraid. There's plenty more I wanted to say, but I've had to race through it.
Thanks very much, Alex. Today, everyone, I'm going to speak in a bit more detail about the mistreatment aspects of the Brook House inquiry. So by that, I mean the breach of the duty Alex explained not to impose inhuman or degrading treatment. Putting that in context, making findings about mistreatment was one of the core aspects of why the inquiry was set up in the first place. It featured prominently in the terms of reference. To explain later, it's really significant that the terms of reference explicitly referenced the Article 3 duty. That became very important for understanding exactly what the chair had to do. The chair had a huge body of evidence in order to make these findings. A huge amounts of documentary material, huge amount of undercover footage, some of which we saw earlier, and then further footage disclosed from the Home Office alongside the oral evidence that the inquiry heard. In terms of the approach to Article 3, this was a full battle between the lawyers at the inquiry. Home Office, of course, didn't want the inquiry to go into detail about any of this, and all of the legal teams for detainees and other court participants on our side were pushing as hard as possible for the chair to make those sorts of findings. All of those debates took place reference to the High Court judgment which led to the inquiry in the first place, which Alex told you all about. I've picked out paragraph 63, which is about the need for the inquiry to have the power to compel witnesses to attend. And we're used to High Court judges expressing themselves in quite sort of reserved, cautious terms, but the language here is really quite strong when you look into it. And the High Court's quite clearly telling us and telling the inquiry that there needs to be a proper investigation about some of the things that were captured in the panorama footage. In the sort of arguments before the inquiry, the Home Office argued, and G4S argued, that even though the chair had been told to make findings about Article 3, what she should do is make findings in a non-legal sense. They made reference to a previous inquiry, the Billy Wright inquiry, where Article 3 hadn't been mentioned in terms of reference, and the chair for that inquiry had made findings in a non-legal sense, using the same kind of terminology, but not making proper Article 3 findings. Fortunately, and despite our concerns during the inquiry, the chair reached a really robust conclusion about this. Very clearly told the Home Office in no uncertain terms that it would be sort of artificial and almost nonsensical to pursue their non-legal approach. And instead, she committed to making proper Article 3 findings. And the chair made reference in the report to the fact that in the Billy Wright inquiry, there hadn't been clear direction in terms of reference. So a good guidance in the future that for all of these kind of investigations, it's really essential that the terms of reference make clear that there needs to be a proper Article 3 investigation. In terms of the approach that the chair said she would take to making these findings, it's a two-stage test. So firstly, identifying where there's credible evidence that there might be an Article 3 breach. Of course, from the footage and the other disclosure we had, there clearly were a huge number of incidents which would meet that threshold. And then moving on to the second stage to making findings about the underlying facts, making proper robust findings about exactly what happened. Which is exactly what, for the detainees, we'd hoped that she would do in the first place. In terms of the methodology, perhaps slightly unusually for what we're used to in normal legal proceedings, the chair used 3 different standards of proof. The main one being the ordinary civil standard on the balance of probabilities. But she also made reference to using the criminal standard of beyond reasonable doubt, and also a lower standard of suspecting something had happened if she couldn't be sure on the balance of probabilities. For most legal proceedings, it's really unusual to the idea of having different standards of proof. We're used to normally having very clear guidance about the standard of proof that someone's applying in a particular context. But this is quite common in inquiries with a slightly more flexible procedure. For instance, in the Harold Shipman inquiry, Dame Janet Smith used about 7 different standards of proof because she was concerned that families of loved ones would be left out basically if she just used one of the main understood standards of proof. So she invented a whole range of standards in order to be able to give people clear guidance about what the evidence had demonstrated for particular cases. And here the chair used those 3 standards that we're familiar with. In terms of the evidentiary requirements, the chair said that obviously they would vary a bit depending upon exactly what was being alleged in particular cases. You can see this in practice, and I'll come to this later in terms of the actual findings of mistreatment. But for instance, there was an allegation that D1527 had his fingers bent back by a detention custody officer called Calvin Sanders, who had bragged about this to other detention officers and then later denied that it happened. In quite cutting remarks in the inquiry report, the chair said, well, people don't ordinarily admit to things that they haven't done. So quite obviously, if he was going around bragging about it, he'd probably done it. And coming on to the particular types of mistreatment. So first, I'm going to go through the different varieties of use of force related mistreatment. In doing so, what I've tried to give everyone is a bit of a summary of what had happened and a few particular examples to go back and pick out from this section of the report. In reality, the detained persons experienced almost all of these, that the things were so bad that in almost every instance where use of force was used, everything was going wrong. But I've tried to pick out some of the core paradigm examples and to give everyone a flavour of exactly what happened. First type outright assault. So these situations where even on the sort of G4S or Home Office account, there really wasn't any justification for force being used. Examples of this are the chair made very strong findings to the criminal standard that D313 had been punched or slapped by Sean Sayers. And then to unnecessary use of force. So these are situations where the chair judged that force was used, but it shouldn't have happened. There was no justification. And D2416, force was used despite the fact that he wasn't being non-compliant. He was shouting a bit, but he wasn't actually resisting what the officers were doing. But nevertheless, they piled in and used force. There also sort of quite shocking example for D687. He was attempting to hang himself. There was a de-escalation sort of process ongoing, several officers involved. One of the officers suddenly decided it would be appropriate to interrupt that process and try and grab him, and all the other officers piled in after him. So that's an example of unnecessary use of force where the de-escalation process should have been allowed to run its course. Even in situations where the force was necessary in the chair's view, she still consistently found that it was disproportionate. In almost every use of force which is discussed in the report, it says the use of force is disproportionate for one reason or another. Often it's in quite shocking cases where force is applied completely unnecessarily to someone's head with no justification. Alongside that, there's the use of prohibited techniques. Stephanie mentioned this earlier in relation to techniques which have been previously banned. One really common one that came up in the inquiry was the use of handcuffs around the back when someone is seated, which is obviously extremely painful, which have been prohibited, but nonetheless was in consistent use in Brook House in this time. E1234 is an example of that happening. There were also lots of examples of failure to apply the techniques properly. So we saw lots of evidence in the inquiry of a very sort of macho culture at Brook House. A lot of these officers were really excited about using force against detainees. But ironically, they were completely crap at it. There are lots of examples of them using force not appropriately, as a result causing detainees much longer periods of pain than they otherwise should have done. An example of this is D149. They don't use force properly, so he ends up being dragged along the floor for a really extended period. And then they give up and they sort of press him down on the floor in a prone position, again for a prolonged period. There's also an issue about failure to provide clothes. Stephanie mentioned this in relation to no-notice removals. There's that particularly shocking footage you all saw earlier, but it comes up in a number of these use of force incidents. They're all very similar, that officers arrive late at night or early in the morning where someone would ordinarily be expected to be asleep, and someone's sleeping either naked or just in their underwear, and the officers pile in. And you saw in that footage, Steve Dix gave the detainee, maybe sort of 10 seconds where he's blinking his eyes and trying to wake up a little bit, and then all the officers pile in their sort of full riot gear. That happens all the time. And the chair made clear that in situations, even if the use of force is justified, the officer should be pausing to allow the detainee either to put on their own clothes or offer them clothes so they can put on. It's completely insufficient to do what they did in the footage you saw, which is sort of roughly hold a blanket around someone. That's clearly not enough to protect their dignity. Next thing is inappropriate and unnecessary use of personal equipment. Again, you saw that use of full riot gear. That's a very frequent example. And there are also some pretty shocking examples of the use of balaclavas. So obviously the balaclava isn't being used at all to protect the officer who's wearing it. The only purpose of the balaclava is to intimidate the person, make it more scary for them. And there are some shocking examples of that being used. D1234 is the best example of that. And in terms of inappropriate use of gear, there is a nasty incident involving D390 and D1851, where the officers piled in full riot and then tried to justify it, saying, well, one of the detainees was repeatedly boiling a kettle to be used as a weapon. And again, the chair said that was not true. They'd made up that justification. Finally, on use of force, there's healthcare involvement. This is something which I think on the sort of legal side, we've been aware of for years, that particularly sort of Dr. Uzarali and other healthcare members at Brook House were quite heavily involved in the process. The inquiries finally proved that they really were. So there's the example D1914, where Dr. Uzerali sanctioned the use of force against someone who had severe underlying health conditions. He shouldn't have been involved in sanctioning the use of force in the first place, but certainly not against that highly detainee. And there are lots of other examples where healthcare staff are present during the use of force and make no efforts really to protect the detainee or fulfil their sort of medical obligations to them. Moving on to other forms of mistreatment, there's frequently abusive words. Again, this comes up in almost all of the cases, all of the incidents. Abusive words are either used directly towards a detainee, and more often perhaps just outside the room, so clearly within earshot, so they can hear what's being said, and a whole variety of very derogatory language is used. There are also issues about bullying. 728 is an example of this. He was on constant observation, so should have been supported and cared for by detention officers. Instead, they're making horrible remarks to him and doing things like preventing him from being able to wash in order to pray. So things which is purely being used to humiliate and degrade him. In addition, the chair made findings. There were Article 3 breaches due to mismanagement of mental illness and removal from association, which I know will be discussed in more detail later on. The one disappointing aspect of this part of the report is that the chair said that there was no finding of torture. The incident that you saw earlier, the first one, was the example where the chair really may have concluded that there was torture. The footage is truly shocking, and the reasons she gave for not identifying it as torture are not very good. Short duration and a lack of significant physical injury. Well, if you're choking and strangling someone, obviously it's going to be a short duration, otherwise it's a murder. In terms of significant physical injury, well, that's just not the nature of what was happening. It was a short-term and very intense form of suffering. And in the ECHR case law, there's no reason for that not to qualify as torture. I've included an excerpt from Gafgen in Germany, the legal case on what torture is. And the chair could quite easily have concluded that that was torture on the basis of the severity of the suffering suffered by D1527 and the fact it was clearly being done with the purpose of intimidating him. Finally, moving on to the conclusions of this section. But the chair's findings would be very helpful for civil claims being brought by all of the former detained persons I've spoken about. And secondly, there's a case for reopening prosecutions the people who did these things. For some of the sort of more minor assaults, 6-month prohibition on cases being brought in the magistrates' court might limit things. But for some of the more serious conduct, there's a case for the CPS reopening prosecutions. Thirdly, now we have robust evidence of what happens in immigration detention. It should be easy when we end up in circumstances where someone is telling us something is bad is happening to substantiate their account, convince the judge this is the context, and this sort of thing is happening all the time. And finally, hopefully it's not necessary, but if we do end up in a situation where there is a future inquiry, at least we have a very clear template from this chair about what to do. So it should be easier next time to show the inquiry what it needs to do and the sort of findings it needs to make. Thank you.
My name's Gordon Lee. I'm a member of the Immigration and Public Law teams here at Garden Court. I'm going to talk to you about medical conditions. In order not to have too much of an overlap, what I'm going to say and what we're expecting Dr. Bingham to talk about later, and also Shu Shin talking about screening, Rule 34 and Rule 35. What I'm going to try and do is talk quite specifically about the experience of one former detainee who was a court participant, who I represented together with Stephanie and some of the rest of the team. The purpose of that is a bit like the purpose of showing the video at the start, because all of us as lawyers and other professionals read a lot of stuff. And it can be quite easy when you're just reading about accounts of ill treatment, reading about accounts of abuse and reading about systemic failures, to forget that at the end of all of those tales is a human being. And the reason I think that video is so shocking, the first time I saw it was actually sitting in Brook House, the Brook House inquiry, is it is a real example of human suffering in a place where ordinarily nobody else would get to see it. So I echo what Stephanie said at the start, which is that we owe considerable debt to the courage of the Callum Tully and his courage of going in with a camera and recording. So there's 2 points to this. The first is to try and identify what lessons have been learned from the inquiry, and second, to try and identify what the future might hold. Again, I agree totally with Alex Goodman, when he described really that we have to remember that all of the disclosure and all of the cases that come out and all of the cases that go to court or will form part of the inquiry are a tiny tip of the iceberg, because the barriers for ill treatment and abuse and failures of healthcare to ever come to light are enormous. And as Alex says, first you need to get a lawyer. Secondly, you need to get a lawyer who knows what they're doing. And thirdly, you need to get enough information and disclosure to interest the court in the first place. So whilst the theme of the defence by G4S and the Home Office was that this was just bad apple, I think it's clear from anyone who works on this inquiry and in detention cases over the years that it's exactly the opposite. The cases you do get to hear about are just a tiny proportion of what's actually going on. What does the future hold? Well, I'll come back to that at the end, but I think probably slightly depressing subject. I think the best I can do is to sort of know what Stephanie says in basically sort of invigorate everyone to a call to arms. I think the next year or two is going to be pretty difficult. The tale of how the Brook House inquiry got to take place in the first place, the work of lawyers like Alex, Stephanie and Lewis, who's here, just chipping away, not taking no for an answer against institutional stonewalling is the only way this sort of thing comes to light. Anyway, so worth, I think, just revisiting how the Brook House inquiry got off the ground in the first place. The Secretary of State had to be brought kicking and screaming. There was a judicial review in cases of MA and BB. And I'm just going to give you 4 examples of the evidence that was put to the judge to persuade her that there ought to be an inquiry. The first was a material which put to the immigration minister of somebody with mental health problems being ridiculed. Secondly, there was an example of someone shouting, a detention officer shouting at a detainee with mental health issues through a door, shouting, "Clean this fucking window or I'll beat the fucking shit out of you. If this keeps going, I'm going to smash the fucking shit out of him. You'll be in trouble." Later, that detainee was so ill that he was taken to hospital and sectioned. Thirdly, another detainee with mental health issues through milk officers who responded, "Fuck's sake, your fucking attitude depends on how it's going to be for you. This is off and you won't have a shower." And then perhaps the most shocking of all of the examples was evidence of the filming of a nurse who, when one of the participants tried to kill himself making a ligature with his t-shirt, they saying, "I'll die, I don't care what I do." One of the DCMs comments, "If he wants to suck batteries, plug him up like a Duracell bunny." And the nurse says, "He's an arse," basically. So that was the background. That's why we got here. The argument at that stage was that the abuse revealed by Panorama was the tip of the iceberg, and more than just abuse by detention officers and detention managers. There was a wholesale failure of medical and healthcare treatment that was given both to detainees and of the screening mechanisms that were supposed to be put in place to stop vulnerable detainees being put in detention in the first place. So even at that stage, it was clear that the argument was that there was much more going on than simply what was being filmed. It's also worth mentioning, of course, that the terms of the inquiry itself were just to look at 4 months, so between the 1st of April 2017 and the 31st of August 2017. So as Alex says, of the 13 detainees that were highlighted, 19 examples of Article 3 ill treatment within that short window. It's also been obvious that he was patently unsuitable for detention. He had complex combat-related PTSD, and the environment of the detention centre already known that things like loud banging, fighting, unexpected noises, he described as feeling like being mentally tortured. In January 2017 and March 2018, after significant barriers to getting properly assessed, he was finally assessed by Brook House doctors who told the Home Office continuing detention would worsen his symptoms. He was not released. So when he enters Brook House for the first time, the detention gatekeeper assesses him. And bear in mind, he's already been assessed by the army, the prison, and by combat strength PTSD. The detention gatekeeper has no knowledge of his medical conditions and writes in the screening review, claims to have depression and PTSD. However, there's no evidence of this. In December 2016, he receives a Rule 35 report, records that his health was likely to be injuriously affected by detention. Home Office responds to that by saying he's fit to be detained. At no stage is he ever classified as an adult at risk. He gets another Rule 35 report in January 2017, again finding that his health will be likely to be injuriously affected, and warning that the risks to his health were very serious. The review by the Home Office just repeats the claim that he claims to have PTSD, despite the fact that there's a lot of evidence that he clearly was. Long and the short of the history is that there were not only barriers to him getting in front of the doctor in the first place. When he did manage to persuade the doctor that he ought to be seen, the Home Office didn't engage with it and didn't review what the level of vulnerability or whether he was at all at risk. And then perhaps most shockingly of all is that when he produced 3 expert reports, each of which from incredibly credible doctors, each of which says that not only was he unfit to be detained, but that his continuing detention was fundamentally injuring him. They were all not just ignored, but no engagement with them at all. And then I'm afraid the punchline to all of this is that he is eventually released. He is successful in an unlawful detention claim against the Secretary of State, and he goes about his business. Then, in August of this year, 3rd of August 2023, he is re-detained. And the analysis of the documentation on screening, you can see where this is going. There's no engagement with the previous medical report. There's no engagement with the expert reports. There's no engagement with the previous Rule 35 report. He is detained on the 3rd of August. He doesn't get a Rule 35 examination until the 7th of September. And it's worth me just reading you the Rule 35 report. The Rule 35 report from a doctor says, as mentioned above, he's currently feeling overwhelmed. Being in the detention centre has brought back memories of past trauma. Feeling low in his mood, experienced flashbacks and nightmares, sleeping poorly. I believe his mental health will only get worse if he is continued to be detained. I believe that there is a significant chance of his mental health deteriorating significantly quickly if he is continued to be detained. So, was he released? No, he wasn't. It took the first tier tribunals grant bail on the 18th of September and then released on the 21st of September. So having spent 555 days in Brook House 6 years ago, he then spends another significant period of time in detention, again, for no purpose, because he remains in the UK, hasn't been removed at the end of any of the periods of detention that he'd gone through. So to finish on a slightly depressing note, as Alex has identified, there has been opportunities for lessons to be learned over and over again by the Home Office. I think the iceberg is part of the system. I think it's designed. I think they know that they will have a percentage of people who will damages for unlawful detention. They know that their screening systems are inadequate. I think none of that will have come as a surprise to it. I think what we have to do is make sure that the tip gets. And sorry about the technical difficulties, but thank you very much.
Thank you to all three of our speakers. We now have 15 minutes worth of questions. If anyone has any, if you would like to say which of the three speakers you would like to direct the question to, no, that would be very useful. Do you have any questions?
Alex, a question.
Do you want to stand up?
I'm Shadrach Avon. I'd like to find out what improvement could be made following the background that's been given on the inquest or future scenarios that are similar.
Yeah, is that to me?
Yes.
Yeah. Well, I think I'd sort of refer you to so in the report, if you go online and get a copy, I've got my hard copy here. In volume 2, at the back of volume 2 are all the chair's recommendations. So she's made 33 recommendations. The two that seemed to me, so the most important were to limit the amount of time that people spend in detention to 28 days. So the way that would work, I think, in practice, is that would be an outer limit, and that you'd need to have an expectation and perhaps a series of other limits at 3 or 7 days. So that the usual practice is that a person is only detained for the purpose of removal. So, for years this debate has gone on, and medical justice has always taken a principled position against detention. What you find is parliamentarians tend not to accept that, because the forced process of putting someone on a plane involves an element of detention. So the argument's always made that, well, we need some detention. But the policy has always been, and the intention has always been, that detention should be limited to that process of removing somebody. So when we talk about 28 days, what we're saying really is that's the outer limit for cases where that goes wrong. But the ordinary process should be for hours or perhaps a few days while you organise and get someone ready to go. But not this process of warehousing people for years on end, like we just heard about the gentleman 550 days in Brook House. So that's and that would make a major difference. For example, even to the main client D1527 who was abused, because it would change the culture within the detention centres as well, because people would be afforded a sense of respect, that there'd be a knowledge that they are there for a limited period of time, they're not lost indefinitely in a system, that they are, instead of being subjected to ongoing bullying, are automatically released at a certain point. So it would transform the culture within detention centres as well. So that seems the headline recommendation. There's then 32 other ones. What we tried to push on the chair was, please don't make too many recommendations, because in previous inquiries, in previous investigations, and she's put a lot of them in volume 3 of her report, there have been hundreds of recommendations. And what that means is that the Home Office often comes back and says, well, there was 130 recommendations, we've done 100 of them. But it means they can avoid all the ones that might actually make a big difference and just do the ones like do a PowerPoint presentation to the G4S about what Rule 35 says, and they say, well, we've done some training. So we tried to limit the number of recommendations to ones that would really make a difference. And that's the key one, that there's a whole body of NGOs and pain groups have got behind 28 days as a kind of compromise, really, between those who would like to see an end to detention centres and those who say it's a necessity. So that's the long answer to your question about what to do next.
Thank you.
It is a bit of an irony, though, that Section 13 of the Illegal Migration Act now prevents a challenge to detention during the first 28 days. So clearly there are two streams running here, and hopefully the one that the chair recommended will succeed, but that's not a great omen for almost the next 12 months or so.
I think it might just be worth adding that that initially
the inquiry's position was they would not look at detention policy at all. So that you'll hear later met Professor Bosworth in her report to the inquiry, she recommended the 28-day time limit. And it was the express position of the inquiry that they would not look into detention limits, that was outside of the terms of reference. And so I think it's really significant that in the end, she recognised that whatever else you might do, you have to seriously constrain by statute this power, because nothing short of that will protect people. And I think one of the reasons she was confident to do that, because that was the inevitable consequence of all the evidence, but also because every single person who was asked this question, including senior G4S managers and Home Office officials, all identified the indeterminate nature of detention as uniquely damaging to the person's mental health and well-being. And so there was, in fact, a consensus across all of the evidence that was given from all sides. And the DCOs at the hard end of it also explained that that's what they recognised as being the most damaging aspect of detention for the welfare of detained people. So I think that was part of the reason why in the end she did something she said she wasn't going to do, which was to look at detention policy at that macro level.
I think the way we got her there, to give credit to everyone who worked for the detainees and the NGOs side of it, was to move her from the position that she and the main counsel to the inquiry began with, which is we've been asked to look at a series of incidents, and we're going to find the facts about those incidents, and we're going to find out which individuals were responsible. And they opened the inquiry very much with that mentality, and we had to, over the 11 weeks of the hearings, continually work round and bring the chair and counsel to the inquiry to an understanding that all of these incidents are rooted in systemic problems that are behind them and that have underlaid what was going on. And they really didn't have that understanding or conception of it from the beginning. So we had to rebut the bad apples narrative repeatedly through the evidence. And by the end, counsel to the inquiry were asking questions repeatedly about rules 34 and 35 and medical treatment and so on. But we had to bring that into the inquiry and to bring their minds to bear and on that analysis. And so I think that the recommendation followed on from that, because once you've understood what the causes of the problem are, once you've diagnosed it properly, the solution, the cure for that problem kind of flows from it. That you need to get back to the root of the problem. So yeah, I think everyone can take a lot of credit for having the inquiry to that position.
You have a question?
Yeah, I have a question for Gordon. What is the Home Office trying to demonstrate by implementing the Rule 35? It does not follow the Rule 35 himself, following the case we just described now.
What is it trying to achieve by not doing things properly?
It's something that he implemented by himself.
Well, I think there are probably two things that came out of the inquiry about that. One is that there was a fundamental misunderstanding on the part of the doctors and the healthcare staff as to the purpose of Rule 35. And there was lots of evidence that Rule 35, some doctors thought that Rule 35 was only applicable to victims of torture. They wouldn't look at the other parts of Rule 35, which were to do with whether or not someone had a disease or a condition that meant that they would be injured by detention. There was lots of evidence about that failure. Secondly, there was lots of evidence about it making the doctors, particularly in Brook House, and particularly the doctors that are named in the report, saw their role as facilitating detention and facilitating removal at heart. And that was alongside the video, some of the most shocking evidence. When I think there's a culture of cynicism and disbelief in Home Office officials, that they don't take medical reports at face value, even if they come from doctors in their own healthcare teams. I think a lot of Rule 35 reports historically are quite badly written. and didn't really do what they're supposed to have done. And I think a lot of I think Rule 35 reports were generally quite difficult to get in many detention centre scenarios. That it was very difficult to persuade a doctor to see you, and then it was very difficult to persuade a doctor to make a Rule 35 report. And I think the other thing that Alex touched on, the adults at risk policy was supposed to be the antidote to the problems of detaining vulnerable people. But there's actually quite a lot of leeway in the adults at risk policy for the detention of vulnerable people. And so even if you've got a Rule 35 report that says that you have a particular medical condition, the policy itself allows for detention in fairly wide scenarios. So I think there's lots and lots of problems. One of them is simply that the adults at risk policy isn't fit.
Might be a good opportunity because we are going to now have a session that is specifically focusing on the failure of the detention safeguards, obviously at heart, the Rule 34 and 35. So if there are any other questions, we could roll them into the next session. And I think because we're so running behind time, if you can bear with us, we won't have a break now, but we'll have a break after this next session. I hope that that's okay. So we'll move on now to session 2, which is session headed detention safeguards and the relevance to judicial review. So there'll be a little bit of a change around, but if you can, unless you need to have a break, some break, we'll start in a few minutes.
Man, thank you.
Yeah, I'm gonna hear the others. Yeah.
So everything was taken. So everything is leading it. That's
Really busy.
That's really. Buildings. Gardens. I did say that they're not going into the details. I don't explain it. Yeah, I mean, it's looking out. They'll just take on loads. She does. I'm there. Teaching on you can start business.
Something else.
Just approach on these keys.
Yes, so my cheapest was.
Oh, she.
Hi, hello, can you hear me?
It's a separate folder that was on as well, so I know it. Signal. Just this one underneath there. That was tables. You just think about it. Don't not go over anything.
That's like a very like gentle. Hi. Hi, can you hear me? It's a bit difficult to hear you. I'm just kind of hearing muffled chatter.
Yes, say it.
Okay, I'm getting a message that you can hear me. That's good.
You'll be on the second. She'll be up here. She will have flies with the ears from them. I'll see it. And then, so you go back. Various yeah, you love but it's standards are hard. They're like just the undergrad, right? Obviously, you know, reading a master's, there's everyone's interested. There's someone not read under reading. It's most efficient. So yeah, it's in the top four students are used to be able to read story stuff. Very intelligent. Sure. Actually worked here for a while. Yeah, went back to work. So international stuff, which has been good. You go to extension kits. It's exciting. Yeah. Have a go to great to go first. Stuff. We're going to start in about a minute or so. And back into the room. I'm sorry, if I can try and I'm just going to show further direction work. What's the matter? It is. Yeah, I can get the appeal. Very sharp way. They were parts of the job. Don't see. So may have to get. I don't see you. Yeah, thanks, everybody. I think we're going to start again now.
The chair.
So we're now starting the next session, which I think slightly confusingly in the programme says it's to do with the judicial review, civil actions and complaints, which I didn't think we're really going to be dealing with any of those, but we're going to be dealing with some of the issues that we've already been looking at about the systemic failures of Brook House that led to the instances of treatment, which became the initial focus of the inquiry and which led to those Article 3 finding in the report. I'm Hamish Arnold, I'm a solicitor at Murphy Solicitors. I was part of a team that represented some individual court participants in the inquiry, but also we represented medical justice, and we had great clients in medical justice because their role in the inquiry was really key. And there was some abject performances by witnesses during the inquiry, but there were the evidence from Steve Schleicher and from Rachel Bingham, who you're going to hear from in a moment. They were quietly devastating bits of evidence, and you can still see them on the inquiry website. You can see looking at them if you're interested in the inquiry, because the medical justice evidence was crucial in allowing the inquiry to properly explore those systemic failings, which led to the instances of mistreatment. I just want to mention at the outset that I think I agree with what previous speakers have said about the tip of the iceberg, and in fact those instances of mistreatment being above a morass of appalling and degrading treatment of detained people in immigration detention. And one of the people that Shushin and I and Stephanie represented was someone who, even when you get to the point of obtaining medical records, nothing was really there because he was quietly deteriorating quite appallingly in his mental health, but just being ignored by healthcare because he'd be referred to healthcare by officers, and he wouldn't turn up to appointments, and then he'd be discharged from mental health services. And so, and it wasn't clear that he was one of the people who was in the Panorama documentary until 2 years later, when we finally saw unpixelated footage of him, and we suddenly realised, well, he's actually a client we've already been representing. He's been in no position to tell us he was being treated like that, and it took us seeing footage to realise that it was him. And I think I was speaking to Lewis earlier on, and the key or participant who was strangled in the footage you saw at the beginning of the day, Lewis didn't know that he was in the documentary until it was shown. He didn't come to Duncan Lewis and say, I've been treated like this. And I think that those facts are quite sort of telling about levels of degradation in immigration detention. But anyway, I'm going to go on to introduce the speakers. First of all, we're going to have Rachel Bingham, who's a doctor at Medical Justice and who, as I said, gave evidence during the inquiry. She's going to talk about what failures in healthcare were illustrated by the inquiry, but maybe more importantly, how that continues to now. And that's an important lesson when looking forward as to if it intends to expand detention. We'll then hear from Shushin Liu, who's to my left, who's a barrister at Bounty Street Chamber. She represented Medical Justice and individual court participants, and she's going to specifically Rule 34 and Rule 35, which we've already heard quite a lot about today, but she'll be looking at that in detail. And finally, Lewis Kett from Duncan Lewis, who was part of a team representing court participants during the inquiry, and he's going to be looking at the use of segregation powers, the misuse of segregation powers, which were quite graphically demonstrated in the inquiry. So without any more delay, I'm going to hand over to Rachel Bingham.
Great, thank you very much for the introduction, and thank you for having me join you remotely to give a medical perspective on safeguarding failures in IRCs. So there's various available definitions of safeguarding for healthcare professionals. We can draw on the Care Act or the NHS or CQC, but essentially these all have in common the protection of people from harm, abuse and neglect. I'll have the first slide, please, Amy. Thank you. So the Brook House inquiry, as we're seeing, clearly shows multiple failures in this respect. But unlike in other healthcare settings, healthcare staff in IRCs, as has been mentioned, have a specific responsibility to protect people from harm caused by their detention. It's difficult for me to overstate the importance of this. In the absence of effective pre-detention screening, the only formal mechanism to identify people at risk of harm to their health through detention is through healthcare. There's no other safety net. And yet there's a severe failure to recognise this role. This is reflected in failures of recognition of various health issues that place people at risk in detention. Inadequate healthcare is seen in failures to provide diagnoses and failures to provide adequate follow-up for both mental and physical health issues. Medical Justice has talked about a culture of disbelief for a number of years now, In this environment, people's health concerns can be dismissed as manipulative, as cries for help, or as behavioural problems. And of course, all of these issues might need to be managed, but they don't trigger provision of care and treatment appropriate to a health issue. The inquiry highlights disinterest shown by healthcare staff and described by people detained, which might be contributed to by a number of factors: staffing levels, burnout, compassion fatigue, and failures of clinical supervision, and so on. And then failures to challenge others. And these ran from the more overt examples of healthcare staff standing by while a man was assaulted, to not challenging abusive language. And then that more insidious but very widespread failure to provide information about healthcare to custodial staff when people were unwell. So to provide education that nurses and doctors were uniquely placed to provide what the person's needs might be, the fact that they were unwell, and then this blanket failure to speak up against colleagues who repeatedly failed to follow safeguarding procedures. And that leads really to sanctioning of use of force. So in the inquiry, we heard of the IRPGP who wrote he was happy, and that runs to failures to raise concerns about potential use of restraints, fitness to fly, moves to segregation, and about detention itself. Amy, if you could click, please. And so clearly these safeguarding failures are seen to pave the way for the harms that we've seen. The next slide, please. The background risk factors make these safeguarding risks particularly likely to lead to actual harm. So in the population, in the asylum seeker population, of course, there are many people who have had a history of torture who would be specifically impacted by detention. People might be reminded of past experiences of powerlessness that could exacerbate trauma-related symptoms. And also being in detention actually deprives people of the conditions like rest and a sense of safety in which they might be able to recover from those experiences. And there are high rates of mental health problems, well documented, both in asylum seeker population and in the former prisoner population. And then these high risk populations are placed in a high risk situation. So we know that mental health is likely to deteriorate in detention. And indeed, people can develop mental health problems in detention who were previously well. And that's definitely been my experience as a doctor at Medical Justice, to see people who had been managing quite a lot of adversity quite well, but have really suffered from significant deterioration in their well-being and their mental health in the setting of detention. And then the mechanisms to manage deterioration in mental health really exacerbate the problem. So we've heard about use of segregation, use of intrusive observations by custodial staff, use of constant watch, use of force. And then the setting, of course, is the contextual risk factors, but I would defer to Professor Boswell's talk later on that. And click, please. Thank you. And so, you know, clearly all these factors alongside failures to identify and report those at risk of harm in detention lead to a really high risk that a person in that setting will be harmed. Next slide, please. Thank you. So I'm quoting the chair's report here. These are some extracts about safeguarding failures that for me really express well the issues that we've been seeing. I will read it. I found that healthcare staff did not sufficiently understand their safeguarding responsibilities towards detained people and were too quick to dismiss difficult or challenging behaviour as disobedience rather than as an indication of mental ill health. Next, serious failings in the application of safeguarding rules, notably around Rules 34 and Rule 35. These failures left detained people exposed to the risk of harm and in some cases caused actual harm. And finally, this was not because the safeguards themselves are poor. There was too often a widespread disregard or a lack of understanding of how to implement them. Thanks. Next slide, please, Amy. So I'll move to an update of where we are now in 2023. The next slide, please, Amy. Thank you. So we've looked at the files, the records and the medical legal reports for 66 clients of medical justice for whom we've done a medical legal report in the period between June last year and March this year. And those 66 clients were detained in IRCs across England, so not only Brook House. These group were selected largely because we had enough information for a meaningful analysis, meaning up-to-date medical records and so on. And all of these clients had significant mental health issues. Many had a history of torture and trafficking. And in 41 cases, the medical justice clinicians had documented scarring consistent with those histories. So this isn't a claim about the rates of those issues in detention, although we know from other independent research that those are very high, but it does show what happens to people with those significant vulnerabilities up to this day in IRCs. And unfortunately, what we found is ongoing severe systemic failures to identify and protect people at risk of harm, no meaningful improvements, failures to identify mental health problems and mental problems with mental capacity, deterioration of mental health in detention in the absence of adequate treatment, increase in suicide risk, and disregarding of measures to protect people who were suicidal or self-harming. The next slide, please. Thank you. A really concerning proportion of these clients with significant, sorry, I just missed a slide. A really concerning proportion of these clients actually experienced use of force. So about 7 of them were subject to use of force or restraints. And 3 actually had injuries documented by medical justice clinicians requiring medical treatment. These statistics, of course, they follow failures of identification. So we're talking a lot about Rule 34, Rule 35 today. Rule 34, of course, being the initial medical examination by a GP within 24 hours. We found that of those 66, only 35 had that appointment within 24 hours. And for the others, waiting times ran up to nearly 2 months, and 3 not seeing a doctor at all. So when we think about this as a safety net, we can see that it really isn't functioning. And where people were assessed, we found that mental health diagnoses were missed in most of the cases, so in 34 cases. Where identified, management remained inadequate, so people were issued a trauma pack, which is a kind of self-help guide for managing trauma in the absence of a functioning psychology service. People at risk of self-harm were given elastic bands, which again is something mentioned in the inquiry report, and ongoing use of force, moves to segregation, and intrusive observations and constant watch under the ACDT process. The next slide, please. Thank you. Many of these people were identified as having a risk of suicide, 43 of our 66 clients. But unfortunately, only 5 of those had a Rule 35-2 report. So this would be the report to alert the Home Office that the person was suspected of having suicidal intentions. So it's a very low proportion reported. 30 our clients went on, and only 3 had actually been reported as being at risk. And the next slide, please. Thank you. But these risks were known in the IRC. So it was not that the people had not been spotted as having difficulties. It wasn't that suicide attempts and self-harm were not known. It was just that they weren't recognised as requiring reporting or requiring safeguarding. So, for example, 22 of the 49 people who self-harmed had been documented as having been put on ACDT. So they were on observation for this risk, but still it wasn't reported. 11 of our 13 clients who actually attempted suicide had been on constant watch. 10 of the 17 had been on constant watch, but only 5 had a Rule 35-2. So even of those people on constant watch, they weren't being reported. And we think that these figures actually reflect very low reporting of risk across the detention estate still. So in that same 9-month period from June last year to March this year, we know from Home Office data and Freedom of Information requests that 667 ACDT episodes happened across the IRCs. So that means across all of the detention centres in England, there were 667 episodes of being put on custodial watch measures for risk of suicide. There were 240 instances of being placed on constant observation, so the most intrusive level of observation, indicating really the highest level of concern. But there were only 26 Rule 35-2 reports. So that I think corresponds to our finding that only a tiny proportion of these issues are actually being reported by the safeguarding process. The next slide, please, Amy. We also looked at people's deterioration in health in detention, and this, of course, should have been reported via Rule 35-1, which, to remind, doesn't require a person's health to have deteriorated. It relates to the risk of deterioration. But we actually found that the majority of our clients with those vulnerabilities I mentioned had deteriorated in immigration detention. And yet, even in that case, only 5 Rule 35-1 reports were done. And unfortunately, in all 5 cases, the person then remained in detention after the report. So in 2 cases, when we looked at the decisions made in those 5 cases, the Home Office had given a decision to release the person, but the person remained detained several months later anyway, decisions on accommodation. So these safeguards, unfortunately, even when applied in this very small proportion of cases, didn't lead to action. The next slide, please. We've historically talked more about Rule 35-3, but I'll just mention briefly today. So reporting of people who had suspected to have a history of torture also remained poor. So we saw people who actually had scarring that our clinicians were able to document who didn't have a Rule 35-3 done at the IRC, although that would have missed the opportunity to document that evidence that they had. And 3 Rule 35s found no scars when our MLR had found scars. So even when done, they were often not adequate. And we noticed that the clinicians tended to include a blank body chart, which implied that the person had been examined head to toe, but actually our clients would often say only their head or hands, scars that they pointed out have been looked at, so the examination wasn't done in full. And the next slide, please. So it feels very unfortunate to be here reflecting on the Brook House inquiry and to be saying this, but I think the take-home message that unfortunately I'd have to convey is that our findings show no meaningful improvement, and to point out that these findings are from IRCs across the UK and up to 2023. So unfortunately, we're not talking about a period in the past in Brook House, but unfortunately a situation which continues up to now. Thank you very much for having me to speak on this issue today, and look forward to hearing more of your thoughts.
Thanks, Stephen.
So I'm going to be talking about Rule 34, 35, putting it into context. And I think following from Rachel, I would concur. I think that's a sentiment from what I've found in the findings of the Brook House Inquiry report, that very little has changed. The question is, what do we now do about that? So I'm just going to briefly touch on adults at risk and Rule 34, 35, linking the two together. And then the findings of Brook House, recommendations, and what now. I think Rachel's already really covered the details of the rules, so I'm not going to really go into them in detail. You'll have the slides. But what is important is Rule 34 and 35 have been around since 2001. So this is not new. And it was introduced then because it was an important safeguard for identifying people who were unsuitable for continued detention. And that's the case of D and K, which Stephanie was in. And you know, that was established in 2006, 5 years after the detention centre rules were introduced. And Rule 34 really, because of the 24-hour rule, means that you ought to be able to say, oops, I've made a mistake. Let me redress that immediately. And Rule 35, Rule 35 has 3 limbs. We're all very familiar with the last limb, torture, although that has also been subject to lots of litigation. But we're probably less familiar with the first 2, the injuriously affected by continued detention and the suicide risk suspicion. But those are 2 other very important aspects of Rule 35. It's not just the report that needs to be produced, it's what happens when the report gets produced, because it is the notification to the Home Office flagging to you need to look at this case again now, not later, not, you know, manage it, but look at it now and ask the right question, which is, should I keep this person in detention? That is a link. So it's not just for the sake of a report, it's the utility of the report. So we then come 2016, travel to 2016 and 2001, we get the adults at risk statutory framework under section 59. And those of you who have worked in the sector, both as litigators and in the NGO sector, will be aware of the string of cases and the various independent reviews that got us to this point. Most recent, before 2016, the Shaw Review, highlighting the importance of looking at vulnerability, not just in a straitjacket under Rules 35, 1 to 3, but understanding vulnerability can manifest itself in a range of ways. And to some extent, obviously, that was important because it ought to have changed the way we look at detaining people who are vulnerable for a range of reasons, and raising the bar in terms of the presumption against detention, and setting out exactly in a more prescriptive way what weight needs to be put on the severity of the vulnerability. So you can see all of that outlined there. But that was 2016. Panorama was 2017. So enough said about that for now. Let's look at the Brook House Inquiry recommendations then. A lot of these recommendations, I've set them out deliberately in quite a lot of detail because the report is dense and it's a way of hoping to shortcut things and help you find the bits that you would like to be interested in reading more on. It's not surprising that there is deficiency in Rule 34. Rachel's already flagged that. One of the things that we discovered in the inquiry is exactly why there is that deficiency. Well, part of it is the contractual arrangements with the healthcare people who are doing the reports, the examinations. They're only allocated 5 minutes. You cannot do a mental and physical examination in 5 minutes. We did have the new contractors come and give evidence, and they go, but we've changed, we've increased it to 10 minutes. The question of lessons learned is built into that kind of evidence that's been given by the new contractor. So that's one problem. The second problem is Rule 34 and 35 although listed differently, are meant to work in sync. You don't need another appointment to raise the concerns that are in Rule 35. And yet Rule 34 and 35, for those of us who work in this area, we all know it's already been decoupled for a very, very long time. And why is that? It's because actually on the ground, the healthcare department, the doctors think they're two separate things. They think Rule 34 is just, oh, are there immediate concerns? Is there infectious disease? Oh, do you have a headache or whatever it is? It's not to do with identification for the purposes of questioning whether the person should actually be in detention. So those are two things that, although sometimes we suspect that, it's clearly confirmed in the evidence and part of the fundamental systemic problem of the safeguard not actually working. Rule 35. Well, most of us who have done any case relating to a vulnerable person in detention will know all the problems with Rule 35. Where do you even start? But hearing the evidence from the head of doctors, to Israeli, and his sidekick, and hearing them talk about what they think Rule 35 is, what they think their job actually is, which is not aligned at all with what the rules actually say. In particular with Rule 35.2 and Rule 35.1, the statistics that are in the report show very few Rule 35 ones during that relevant period. And if you look at the immigration statistics now and the publications by Medical Justice, you will see that very little has changed. There were no Rule 35.2. And bear in mind, 35.2 is about suicide risk, it's about suspicion. Suspicion is a very low threshold. And yet when we come to looking at ACDT, which is supposed to be managing self-harm and suspicions of suicide risk, where there's hundreds of such ACDTs, you need to wonder what happened to the Rule 35.2s? Did someone gobble them up? So that is something that none of the doctors could explain, none of the healthcare could explain. They all know about ACDT, they all know about ways in which you have to monitor, but that's not the point. The point is notification. The point of the safeguard is to see whether or not this person needs to be let out because of their vulnerability. And that is why the inquiry found that there was a serious systemic failure and breakdown in safeguard adults at risk. And I must say, I mean, the reading the Brook House inquiry report, it's like reading your career sort of encapsulated in all of this, and reading everyone on the team's career encapsulated in this, because we all know what the problem is. And we've had successful reviews, but none of them as bold as saying, spelling it out straight out, telling it as it is. This is a serious systemic failure and it really, really needs to be fixed, instead of glossing it and dressing it up. Then there's the inappropriate use of other mechanisms. Well, there's ACDT, which I've touched on, which is simply not therapeutic. And what became really, really clear is that actually the people who are responsible for the ACDT are the detention custody officers, those people who were the ones subject to panorama and the use of force and segregation and abusive language. They are in charge of ACDT. And ACDT are just some scribbles in a log that's handwritten. It's not a formal document that is presented to the Home Office as, look at this person, let's think about why they're here. Similarly, IS 91RA Part C's, lots and lots of alphabets. IS 91A Part C's are used instead of Rule 35.1s and Rule 35.2s in particular to raise concerns about someone's suicidal ideation, their deterioration in detention. And as Hamish mentioned, the one client that we had who were mentally incapacitated, lots of Rule 35.1s, so not lots of Part C saying, oh, just a bit weird, like he's just acting a bit weird. Well, that doesn't actually go to the Home Office. I mean, we found out in the evidence that it goes to a department in the Home Office, I think called step new. And then you ask the person who's given evidence from that, well, where does it go? Oh, it gets uploaded to the system. Well, that's great. What do you then do with it? No one could actually give us an answer. And it's very clear that yet the healthcare department and the doctors routinely use Part C because they think that's the way to deal with things. Why do they think that? It's because they don't know, they choose not to know, or they just ignore the rules as they are written in plain words since 2001. Inappropriate use of satisfactory management. This is like deja vu, basically, because it's been clear for many, many cases, even before the Shaw review, that this is simply not an appropriate threshold for when you think about letting someone out, because satisfactory management in a non-therapeutic environment inherently is harmful. And Shaw has said that point blank and said this must be stopped. And we think it's stopped, but well, it's somehow the evidence that has emerged from all of the witnesses seem to suggest that it continues to happen. Absent safeguards of mentally incapacitated. I mean, you can just look at the cases that Stephanie has done in VC and ASK MDA in 2018 to know that this is an absence and a gap that has continued to happen. People who can't speak for themselves because they're unable to do so. And there is no arrangement to facilitate them to even begin to make representations and participate in decision-making about themselves. And for the first time, there is a finding in an inquiry in this respect. And one that's really important because the Home Office has oftentimes used the 2020 DSO to say, oh, well, we fixed it. You know, the Court of Appeal gave us a slap on the wrist, but we fixed it. Well, clearly they didn't. And clearly the inquiry agreed with all the evidence that's been presented by the team that that hasn't happened. This slide you can read for yourself, but, you know, guess what? Newsflash, lessons haven't been learned. And that was probably one of the depressing findings of the inquiry report, that, you know, nothing has changed. Why hasn't anything changed? And because there's this blatant disregard and an inability to accept criticism and to reflect on them on the part of the Home Office. And I've set out some of the recommendations that won't be surprising, but because I'm running out of time, I'll just go to what my thoughts are about what now. And I was trying to think of a way of doing this in a little bit more light-hearted way, because it is quite depressing when you read about Rule 34 and 35 and how little has changed since 2001. So I've decided that we could do, instead of a 12-step program to reckoning your wrongs, maybe we'll shorten it to 8 steps, because that's easier for the Home Office to get from A to but, you know, these are very basic suggestions. Read the report, look at findings, acknowledge that you've done some really bad things, and done some really bad things, not just because, oh, it's just the barrow of bad apples, but because there is dysfunction in the system that you've designed. Admit that it goes beyond the relevant period, and admit that you are responsible for setting the direction, the tone, the policies to make things better. You know, that kind of recommendation sounds a lot like what Wendy Williams said in the Windrush review lessons learned. Similar words, is it actually going to entrench itself? So these are just my humble suggestions to the Home Office as to the steps to their recovery and their lessons learned. But really, in all seriousness, though, what can you do? Well, there's always the carrot and stick approach that we have always consistently tried to adopt. The stick is litigation, and here are some examples of the ways in which litigation has drawn things out into the light. But litigation can't succeed and take us to the finish line without advocacy and contribution to policy, which all of us in this room can do more of, notwithstanding the barriers that we face with the Home Office. That is something that we can do. So that's sort of the way I want to round out my bit. Thank you for listening. Over to Lewis.
Just before Lewis starts, I think Appendix 4 of Volume 3 of the inquiry report is a section on previous recommendations where the panel chair said there have been more than 1,100 recommendations made by various reviews prior to the inquiry, which led her to say that there's a dark thread through her report, which is the failure to learn lessons. And I think that maybe also goes to what Alex said earlier on about the need for political change, because sometimes these things aren't going to be enough, and we're at the moment now where some thought about political change needs to be given. Anyway, here's Lewis to talk about segregation.
I'm just going to move on to a slightly different topic, give an overview of the use of segregation in immigration detention, which is quite a hidden part of detention. And what I want to do today is just read out some of the key themes and show you how it can be challenged. So just as an overview, again, the rules of segregation found in the detention centre rules. 2 separate powers: segregate, removal from association under Rule 40, and temporary confinement under Rule 42. The vast majority of these occur under removal from association, so today we're going to focus on that rule. And this presentation is basically going to do an overview of the requirements of when a person can be subject to removal from association and the ways it can be challenged, mainly by the procedural requirements, and then looking at sort of the substantive reasons. And in doing so, we're going to look at the findings of the inquiry chair and some of the problems she identified. So I've just set up Rule 43 there. Well, the main one, that's Rule 41, gives you the test, which is where it appears necessary in the interest of safety and security. That person should not associate with other detained persons. The Secretary of State may arrange for that detained person's removal from association. It's supplemented by the Detention Service Order 42/2017, which came in July 2017. So it was active during the inquiry. It came in, and was one of the complications of officers not knowing what the requirements were. So just as an oversight of some of the types of challenges you can bring to it, there's been very few court challenges specifically to the use of segregation in immigration detention, but there's no reason why they shouldn't be brought. And I've just given you an overview of some of the ways in which you could bring it. So first one is just a breach of the rule itself, on the basis of a judicial review on standard public law grounds. So there's an example there of the case of Moasa that we brought in 2017, where there's a breach of Rule 43 because the Secretary of State failed to authorise it beyond 24 hours. Even in that case, there was only a few hours beyond it, but it was still found to be unlawful. Equally, it could be brought as a breach of Article 3, again, case of Moasa. It could also contribute to detention conditions, treatment being in breach of Article 3. HA Nigeria is an example, but in the inquiry, a lot of the 19 Article 3 findings the chair made, segregation was often wrapped up as an element. It could be an aggravating factor for damages in unlawful detention and false imprisonment claims. So, particularly if that detention is already found to be unlawful, the use of segregation, even if it is lawfully authorised, could be an aggravating factor, given the sort of the damage it can cause. And then finally, the Rule 40 process has also been found to be procedurally unfair. Someone with significant mental illness, again, this case keeps coming up, but Hamish and Stephanie's case of VC. So looking at the procedural requirements first, so there's 2 routes. So it can be authorised by the Secretary of State under Rule 41, or it can be the centre manager for the first 24 hours in cases of urgency. You can't authorise beyond 24 hours without the authority of the Secretary of State. Detainees must be given written reasons within 2 hours. Particulars of removal from association needs to be recorded by the manager. In the DSO, there's various annexes of what decision making and things need to be filled in. And they must be visited daily by the centre manager, GP, and someone from the Home Office. Brook House, we've seen medical records at the moment where actually they're only being visited every other day by a GP. And I think sometimes it's even a nurse, it's not even the GP. So authorization is really important. It has to be in writing. It has to be by the appropriate person to be lawful. Holman and Moassa basically said that to argue that the absence of the required authorization is merely procedural or technical is to treat it merely as a rubber stamp. It's not. And again, in that case, there was an Article 8 breach found. 4 hours was found to engage Article 8.1, and because there was no authorization, it was found not to be in accordance with the law under Rule 42. Because it was only a few hours, it didn't sound in damages. There's no reason why, in theory, the judge said it couldn't be a more egregious breach. Using Article 8, we sort of used the case law from Munjaz for UK. You're essentially looking at interference with physical and psychological integrity. So as I've said, there's non-urgent cases for Secretary of State, and then the centre management cases of urgency. The Home Office authorisation is largely quite straightforward. The DSO sets out the certain ranks that's got to be. In TM Kenya, which was an appeal from Moassa, that basically said it was okay for local immigration managers and contract monitors to authorise on behalf of the Secretary of State. Where in the inquiry it's got a bit more difficult in terms of authorisation is Rule 42, when the manager is authorised in cases of urgency. The manager's got a specific statutory function under Section 148 of the Immigration and Asylum Act. Brook House at the relevant time, this person was Ben Saunders, G4S. What we found is that he was constantly delegating his job under Rule 42 to junior managers. But it's quite clear in the detention centre rules under Rule 65 that you have to have a scheme of delegation in place, and the Secretary of State's got to approve for that to happen. And what we found out is actually there was no scheme of delegation in place. So every time a junior manager was authorising Rule 40 in Brook House, it was just unlawful for lack of authorisation. And so, yeah, just looking at this, there was 232 of the 236 uses that the chair was able to look at were found unlawful for this reason, because there's just none of them were approved by Ben Saunders himself. It was duty directors, detention centre managers. And so the chair noted that the Rule 40 and 42 were poorly understood, being misinterpreted and misapplied routinely. And also just note the actual urgency itself was constantly being misused. Circumstances where there's plenty of time to get hold of the Home Office. There's a case of 1527 on the 4th of May. He was protesting on the netting. The whole centre was shut down. The Home Office were there, but apparently they didn't have time to ask the Home Office, so they used Rule 42. What we've seen evidence from the current centre manager, Steve Hewer, confirmed that it was still not being used correctly, still no scheme of delegation of his powers, and we've not seen anything to suggest that any other IRCs have got those powers. So moving on to the substantive test under Rule 40, it's a strict necessity test. Moassa, again, from Holman, which was the threshold is test is one of necessity, no less test will suffice. There's sort of two elements to Rule 40, so it's not just necessary in the interest of safety and security. It's got to be necessary in one of those interests that a detained person shouldn't associate with other detained people. So if you've got a problem that's actually linked to a detention officer, so maybe you've had a fight with an officer, technically it's not really allowed under Rule 40 to use that power. Not that it's stopping people, obviously. So the DSO, which again came in July 2017, it was a week before the master was heard in the High Court. We had a challenge to the absence of guidance, and I think it got rushed through a bit, but it was there. Just gives some practical procedural application of the rules. So it must be a measure of last resort when other options have been exhausted, to be justified to the risk, minimum time necessary, no advance designated blank use for specific types of cases, can't be used as punishment. There's also guidance on mental illness itself, harm risk, which we'll come to. So I'm just going through some of the examples of the chair and what she found in terms of when she reviewed the Rule 40 decisions. There was a lot of concern that it was being used to punish detainees. The duty director, Steve Skate, was the second most senior officer there. The G4S said it was the only policy they had to deter behaviour. The DCM said it was a repercussion for misbehaviour. At Duncan Lewis, we did an analysis of the Rule 40 documents that we got disclosed. We managed to look at 147 decisions. 40 of them actually used the wrong test, which was from the prison rules, which is good order and discipline. As you can hear from that, discipline is more of a wider powers under the prison context. So again, I've given an example of D1527 on the 4th of May. He was taken to segregation because he went on the netting and was protesting, and that was just seen as an automatic consequence. You go on the netting, you protest, you go to Rule 40, and the officer DCM Dix, who authorised it, give live evidence and just said, look, that's what we understood the rules to be. We've now seen the DSO, which is clear, no advanced designated blanket use for specific type of cases, and that's clear, but that's just a specific case of punishment. It still seems to be continuing. We've got a imprisonment claim where the client at the moment was again protested twice on the netting, went to Rule 40 twice. I'm just flagging there that the regime itself can often be used as punishments, removing televisions as part of the regime, restricting internet access, even when there's no link to the actual safety or security risk. Another example the chair was concerned about was using it for the administrative convenience of staff. This was particularly around removals. So E-Wing at CSU, where people were segregated, was routinely used the day before someone was about to be removed, because it seems a much more controlled environment. The chair had a lot of concerns about that. And it was particularly common during charter flights, because you can imagine, given the pressures that the staff had to get a large numbers of people out, they'd find the most disruptive people and placed them in the CSU. There was actually an IMB report in 2020 that said that actually 45 people were simultaneously put onto Rule 40 in advance of the Jamaica charter flight. It seems to be as well, it's going back to sort of the financial penalties and what the contract says about removal as well, because G4S and Still Serco need to remove people. It's the whole point of detention centres. And if they fail to present somebody to an escort for removal, then they'll be fined. So using segregation and use of force is just a routine thing that they need. They could get their ultimate job, which is to get these guys out. And they would use every tool at their disposal. It's often used as well. There's a fear that somebody would resist removal by self-harm. I've given an example of D1914 on the 27th of May. Someone with significant cardiac ill health, a history of heart attacks, but because of some intelligence they had that he might try to overdose to stop his removal, they took him by force. That force itself was found to be excessive and entirely unnecessary. He was taken to Rule 40 as part of this, and the chair found credible evidence of a breach of Article 3 for the entire incident. So just as a final example of a concern of the chair is use to manage mental illness. I've just set out some of the conditions of it from the DSO about managing serious mental illness and use of in risk of self-harm and suicide. It's all about exceptional circumstances. Is this the absolute necessary thing you need to do? Is it a last resort? So, I mean, as Dr. Bingham's already identified, there sort of seems to be two concerning patterns about how officers deal with mental illness. It's not just managing mental illness, but it's also misinterpreting symptoms of mental illness as behavioural issues that need to be managed. And I've just given some quotes there from Dr. Bingham and Dr. Patterson, who I also understand is speaking today about issues with mental health treatment and the impact of segregation, but also the idea that it's manipulative, attention-seeking behaviour. It's not mental illness, and therefore we need to manage it the best way we can. I've given just an example there again of D1527. We saw the video at the start. At the time that happened, he was on Rule 40 in E-Wing on constant watch. He'd been called an attention-seeking prick in the build-up to that. He got significantly worse in segregation. He attempted to ligature twice whilst being there. We ultimately saw he was assaulted by officers. Given just a little bit of his statement there, But he said being in Ewing with nothing to take my mind off my thoughts just made me feel more suicidal. Being in Ewing is like a prison inside a prison. Also just mentioned that briefly, but I've only got a minute left, about healthcare, again, being a big part of it, not recommending when a person should be taken off Rule 40. If you've got time, look at the slides later on. I've given you a video of the famous Dr. Uzarali doing a Rule 40 round where essentially it takes a minute to go through 10 detainees segregation unit. It gives you an idea of the level of oversight. They're still concerned that it's ongoing. The centre director and the current head of healthcare didn't give any reason to suggest it wasn't changing. They talked about the CSU being a quieter environment for the mentally ill. Practice is still ongoing. We've got a case listed in February called NT, placed on Rule 40 for 11 days, despite having schizophrenia. They thought it increasingly bizarre behaviour that he was having, and they put him on there to make him comply with his medications, and there's significant concerns about that and its compliance to the Mental Health Act and the Mental Capacity Act. I've got some final practical considerations, but I think I may be out of time, so it may be something to read in your own.
Your best practical consideration.
My best practical consideration is always get the paperwork, and it's an absolute nightmare because it's not standard disclosure. You aren't going to get Rule 40 in a subject access request, even when you've got litigation and you're asking for disclosure. Half of the GLD lawyers I speak to don't actually know where the paperwork is. Their client doesn't know where to find it, and it's often delayed. But you've just got to be persistent, because when the rule to get a written decision within 2 hours for a detainee only gives you half the story. There's a 20-page booklet that's behind that. That's the thing you need to get.
Thanks a lot, Lewis. One of the functions of contracting out is that all that paperwork of segregation is generated by the contractor, G4S, as it was in Brook House, which means, as Lewis says, the Home Office doesn't necessarily see that paperwork as its core documentation when it's making disclosure under the SA subject access request. So you need to get that paperwork to you. There's monitoring sheets as well of every day of segregation that shows, the lack of care that are given in units. So we have 10 minutes now for questions before we take a break, and then we're going to be back on track, more or less.
Yeah, pretty much.
So I don't know if Rachel's on the line. Can you hear us, Rachel?
I think it was in Egypt.
Yeah.
Holiday, I think.
So it might be only questions for Lewis and Shushin, but are there any in the room? Yeah, here.
Good evening. Thank you so much for this enriching experience. My name is Kavita. My question is more on the ground of the preparatory stage of the inquiry. I was wondering, we're just getting a surface level idea of what you guys must have been through to get justice for these people. In terms of practical difficulties, once you were researching or on a factual basis or on a legal basis, what were challenges that you faced? And that is not a part of this right now. So if you could just share that.
Yeah, Lewis, do you want to get that?
Yeah, I think in practical, I was talking about the segregation is getting the documentary evidence to prove. Most of the stuff that happened in this inquiry happened because there was an undercover officer filming. And actually, once you could see the footage and you can see what's going on, get a much better idea, because it's all well and good at being paperwork. So officers will write use of false reports, say what happened, but they're all probably sat in a room being like, "Oh, what are you putting?" So they're never going to be actual accurate reports, and getting the footage is so key. See, beyond undercover footage, because there's a once a generation thing that might happen. They do actually have body camera on footages they're supposed to wear, and CCTV and handheld cameras when it's a planned control and restraint. So actually, that footage usually does exist. And you see the second example that Stephanie showed at the start, that was just from a handheld camera. And getting that document, getting that evidence is crucial. And we're finding even now on case when we know exactly what we're looking for, we're still not getting it, having to go through professional standards and full investigations, asking where the footage is, not being given it. And I think that's, if there was better disclosure as a system, I think you'd uncover a lot more.
Anything to add, Shishin?
I think Lewis and Hamish and the solicitors were the ones who did a lot of the very heavy lifting on sifting through the vast amounts of disclosure that we got, which came like buses, basically, and they all had funny codes. And so you had to work through the documents to figure out what actually is important. And if you didn't work through the documents like they all did, you don't find the gem of the sort of flag that tells you there's something more to this. But that also just for me, all of that just shows how not transparent our immigration detention system is. Even when we think in the work that we do, we get subject access requests. I mean, it's the tip of what actually is behind, and it's about really persisting and getting the document.
So not just solicitors, but the caseworkers as well. Really need to understand.
Yeah, here first and then to the back.
You need me to stand up, or can I just?
You can just introduce yourself and shout.
My name's Ben. My question was more looking forward, really, in terms of the impact the Illegal Migration Act will have, not only on the size of the detention estate, but also the types of people who could be detained. Do you envision that having introducing bespoke issues to healthcare teams in detention centres? Do you think it will just make things worse with the issues you've already outlined, or otherwise?
Is that directed at anyone in particular? Or?
No,
I'm
not sure we necessarily need more rules. I think we just need them to actually understand what the rules are and be committed to actually applying the rules and being skilled up to do so. That's one thing. But obviously there's a fundamental problem in the light of the Illegal Migration Act, because the idea is to funnel people into areas that no one can see them, that they become invisible and hidden. And you see that in Manston, you see that at Wethersfield, you see that at Bibby, that they can't actually access and come to light because they become invisible people. That's a fundamental political problem. That no number of safeguards and the amount of training is going to change. It's very much institutional, cultural. And, you know, if you read Wendy Williams's executive summary, which is only a page, it just says the Home Office must recognise the role that it plays in its formulation of policies and rules. And policy, notwithstanding the object of migration control, has to be rooted in humanity. That's the thing that is missing, and that's not something you can train or write policies about.
So I'd say with the issue of the Illegal Migration Act, it's the automatic detention of asylum seekers coming in, and essentially what would happen is just a much more vulnerable cohort all going in at the same time. You see if you look at when you went through the stats of what the inquiry showed, you look at where the spikes of use of force and segregation and pressures on the Rule 35 system. It's often when there was charter flights. So if it's especially the charter flight to Rwanda last year, you'll see the spikes in Rule 35, use of ACDT, because you've got so many more vulnerable people coming in. It's the same at the end of 2020 when you had the last of the Dublin 3 flights going, so you've got more asylum seekers coming in. And I think it is just going to make all the issues in detention much worse, because you've got a much bigger cohort of people much more unsuitable to actually coping in that environment.
There's someone at the back.
Yeah, just to say that just a small anecdote from yesterday afternoon. I'm visiting somebody as a volunteer visitor in Brook House. He was threatened with segregation if he didn't agree to sharing a room. As you know, Brook House is filling up very fast at the moment. And my colleague Hannah has concurred that somebody else had a similar threat. That's a threat with somebody with serious mental health problems was threatened with segregation.
So 2 good reasons why I shouldn't be in segregation. But was there anyone else? Yeah, and then.
Yeah, I think this is directed at Shushin. I'm Pierre Reclus from Belfort Immigration Detainees. We have a case which Mark Hyland might comment on later on, but I think he might have taken it on. But basically, there came a point some time ago with Brook, where there was a delay, and there still are delays, with drawing up Rule 35 reports. And we wrote as bid to the Home Office to complain about it. And the response of the Home Office was, there's nothing in the rules that requires these reports to be produced within a time frame.
Yeah, you have to get to your question soon.
Albeit the policy, is to consider them very quickly. And I suppose what I want to hear is tactics under the IMA for speedy consideration of Rule 35 reports and IMA cases, what lawyers and others need to be doing to try and get a response quickly from the Home Office.
A response to the Rule 35 rather than the Rule 35.
The Rule 35 to be considered in order to then get a response quickly.
So, I know everyone's worried about the IMA, but the rule, it doesn't change Rule 34, 35. It doesn't change the adults at risk policy and the principles behind the statutory guidance, which is shortest amount of time detained where necessary. So everything to do with the way in which the parameters are drawn are to have speedy identification, speedy consideration. I mean, that's the underlying principle. And the IMA can't really, by just being there and by its odious nature, fundamentally change that these safeguards are safeguards and they haven't changed. And so, the fact that it doesn't spell it out doesn't mean that, it's got to be coherent in line with the principles of speedy, least time possible.
I'm so sorry, I'm going to have to wrap it up there because I'm being gestured at. I'm going to give speedy. So thanks very much, everybody. We're going to take a break until.
Yeah, so we've got a chance now for you to move out of this room and I'll open the window and get some. And you can go downstairs as well, so it'll be a bit of a break for you. If you can come back at 5:10, that would be fantastic. And we'll move on to the next session on some stuff downstairs. And there's more time for questions.
Yeah, I know. So, Andrew, I'm watching you online. How's it going? Something nice to do it. Now the sometimes I'm very slow. But I don't see plus. That's my tax. I don't understand it. That's what I'm saying. But you I think I think That's no different. That is That's changed. Yeah, we have struggled. It's good. That would be really easy. They have these name of So they did it for seasonal whatever. Oh, yeah. So much money. That's just yeah, well, that's really nice to meet you. Not short.
Lots of hours.
I think we can work. So it's what's the subject? Yeah, but it's here. It's this is how they put it. So yeah, right. It's not this function. Mark and I both worked on it. Yeah, so I had Mark the other, he had D and I had K. It's goes. No, I think it's Julia gets Grace. Yeah. Sorry, you're sorry. Well, even if they say I'll say hello. Yes, that's right. How's it going? Not too bad. So, how's it all going? Well, it's to stop these partner. What this is important picture for the inquiry and then after.
So you're the
No, just sort of story. Yeah.
So not really just it's not things at the home office. Dealing with one person. I think individual. It's I just what's on top.
It's actually quite I know. I don't know, a kind of education.
It tells you English you have.
He's got to go. I was gonna say, it's an connection. Yeah. So freaking through. You saw where you were. That's a civilization.
So to an extent,
It's myself here today. And then I spent some money. So it's like, so like, according to the filter, so it's like, it's live. It's visual. It's sorry to be a slide, but it's like it's already great cat. Good to see us from like this. No, this is so I think if you go, institution, I'll see you. Just think about it. Yeah, this is really depressing and fun. Twice a week. So, when you go for a drink after work, see. So, it's like,
See us then.
I wasn't very conscious that whenever I start to get like something that's stop. Yeah. It's like I wonder, maybe you shouldn't. Yeah, yeah, but I can always make it like it sucks. I'm not seeing the thing, so I'm not. Well, I've seen it. Beginning because it's quick. Time. Well, it's like so I'm sorry. Okay. I said it's working with you. Yeah, it's text. Yeah. I've had the only that one, but yeah. Next week, so I'm kind of like, this is fine. I'm not going to change or put it in your like. I've had a couple of the same ones successively. Terminally last week, an interim hearing Friday for this one. So. Understanding if you help that possibly come to here, but if it's fun. Yeah, I couldn't God, like, oh, exactly that. It's like, do you think they can like we have this interpretation, maybe something's fixed. Well, imitation.
But the frequency of Mr. Armstrong.
Yes.
Hi guys, just phone checking.
Hear us?
Yeah. Can you hear us? If you want to move back, please. Yeah. Yes.
Yes, I can hear you clearly.
That's we can you check you.
I can hear you unclearly.
Nick, you don't look as good in 2D.
Sorry?
Yes,
looks much better in 3D.
It's so better, I've switched.
It's good.
Perfect, thank you.
I didn't understand that instruction. I can hear Dr. Patterson clearly. I can't hear anything else clearly. It's very broken.
That's because there's so many people around.
Right. I heard that bit.
Yeah, I was commenting on your 2D flatness compared to your much more moving 3D-ness when you appear in person.
Okay, well, no, don't know what to about. Who is that, by the way?
Yeah, true.
No, can't hear.
Yeah, Mac.
I think if you get behind the desk, you can be identified here.
Yeah.
chopping glass.
I'm offering. Nice. See what you do outside.
Sorry, that wasn't helpful. Really.
Like,
People are an active in the black.
Very much.
We all mostly time we started.
Go visit. Yes. Till they get to see. Just literally making it.
I'm going to log off and log back on again in the hope that it improves my microphone. Hang on a moment.
We can know it's not your microphone. We can hear you very clearly. It's great. Please stay on the call and just mute yourself for now.
I didn't know this. You said you're moving. So you said you were going to Jesus.
So you didn't.
You guys are going to talk about
Let's do that first.
yeah. It's only going to be, I'll take that. And then we'll send it to me sometimes.
Yeah.
And then
It's going to go actually. I don't want.
So what you said on this, it doesn't go up. Just like what?
needs readmitted.
It's like rates and curates. I think curates just
yeah, other video. Yes. Otherwise, so many works.
this year very much. And before I do it, it's a lovely.
But like, that shouldn't be up to.
The budget is much quicker.
Actually, asked. Never been
Wait for that.
It's not been super. There's always other just to get everything. It was a sin. So it's other. Let me sit in your seat. Be applied. See why this one.
Actually, let's see. Just send it to Steve. Signal. It's basically very
Yeah.
your child, but also not just every child. And then fine art. Yeah. Just be really true. So
Explode of cards.
Do those anymore.
I think this is the last one. Right? It's supposed to end at 6:30, so probably 6 and no questions. They're excited.
I'm just. I think I'm first. I think that was the one. Don't actually. Different three people.
Sign back in.
Change.
He's got. I just want to see it. It's confusing. It's run off. Don't come on.
Just to be, was there.
I need to make that to me. No, I'll do that 6 months. Yeah, it's too much. Back out tomorrow. Yeah.
Yeah. Go on. It's broken.
Times to tell what you want to sweeping up at night. It's going to be.
Specifically valleys. Yeah, so. You were there to hear it. She did our master. Yeah. Yeah.
I feel like I do need to understand.
Wasn't working. Sort of, and then most of the prisons weren't working. So no historical imprisonment claims. We could release it. Shout as efficient. Sensible, very, very close to same instances. Or two so we took the seats. Get some food. Enjoy that.
We can have that.
Hi everyone. So we're going to get started. Welcome. This is panel 3 on the use of force, which, given panorama documentary and everyone's understanding of abuse being physical, I think it's and obviously the importance that it played in the inquiry. It's a great panel to be on. My name is Mark Hylands. I'm a solicitor at Dyke & Pearce Glynn. I am joined here with Una Morris, who is a barrister at Garden Court. Online, we have Dr. Brodie Patterson, who is a trustee at the UK Restraint Reduction Network, chair of the European Network for Trainers in the Management of Aggression, and an honorary senior lecturer at Queen Mary's University. And also, I'm pointing online, but they're not there on the screen, is Nick Armstrong KC. He is a barrister practicing from Matrix. Myself, Una, and Nick represented 2 core participants, the 687 and Gatwick Detainee Welfare Group, as well as a number of witnesses, including BID, Detention Action and Inquest, in the course of the inquiry. And just to touch on the 687 very briefly, as a bit of an introduction, as he was one of the 2 claimants in the judicial review proceedings, which led to the inquiry being established back in 2019. So the proceedings started in 2017, 2018. And at that stage, he had been in detention. He was one of the longest serving, and I say serving because it's like a prison sentence. He was there for about 32 months. And I know a lot of people want a time limit for 28 days. In circumstances where you have people detained for 32 months, it's just ridiculous. But we only saw a brief little clip in the Panorama documentary of him, and it wasn't until I think September 2021, about 4 years later, similar to how Hamish described with his client, that we saw the unpixelated full version of what occurred to him at Brook House, the use of force on the 13th of May 2017, including audio, and that was not because of the body-worn cameras that all of the officers should have been wearing, but because of the BBC journalist and his undercover camera. So but for this journalist, none of the safeguards worked, and he has been dismissed since then as a liar. It was only until 4 years later that with this video footage coming out through the course of the inquiry, it wouldn't have otherwise come out, that he has been confirmed as not a liar, as the Home Office PSU investigations would have you believe, not inconsistent or uncredible, but having been telling the truth the whole time. And I think this inquiry has done great things for him, but there are so many others that don't have a public inquiry looking into their circumstances, and that's the problem. We're going to move on from me because the speaker is going to talk about a few things in the context of use of force. Una's going to talk about necessity and proportionality and maybe stray into other areas, maybe not. Dr. Patterson is going to focus on mental illness in the context of use of force. And Nick Armstrong is going to tell us a bit about Article 2 and Article 3 investigations, and may do a bit of a sweep up in terms of other issues that he considers interesting. We'll do some questions and answers at the end. We'll keep them, if you sort of let me know during, if you wave, if you have a question, otherwise I'll pick them all up at the end. And yeah, Una, take us away.
I think we've got a video clip before me.
Oh, I was meant to tell you about that.
The detainee was born in Somalia. Just been told about the transfer to health. to the same end.
So thank you, everyone. I will be talking about use of force and whether it's necessary and proportionate. So starting off by looking at the legal and policy framework which was considered by the inquiry. The inquiry looked at Rule 41 of the Detention Centre Rules 2001, the Detention Services Operating Standards Manual, and the Prison Service Order 1600 on use of force. And we'll just look at those in a little bit more detail. So starting with Rule 41, as it says there, use of force, a detainee custody officer dealing with a detained person shall not use force unnecessarily, and when the application of force to a detained person is necessary, no more force than is necessary shall be used. And second, no officer shall act deliberately in a manner calculated to provoke a detained person. The inquiry also looked at the Detention Services Operating Standards Manual, and that's in similar terms about necessity. Says the centre will ensure that force is used only when necessary to keep a detainee in custody, to prevent violence, to prevent destruction of the property of the removal centre or of others, and to prevent detainees from seeking to prevent their own removal physically or physically interfering with the lawful removal of another detainee. And secondly, force will only be used as a measure of last resort and strictly within the terms of Rule 41 of the Detention Centre Rules 2001. And we'll come on to this in more detail later, but you'll see that this is a prison service order, not an order which is specific to immigration detention, but it was considered by the inquiry because that was in force in Brook House and was being applied. So the Prison Service Order 1600 states that the use of force will be justified and therefore lawful only if it is reasonable in the circumstances, if it is necessary, if no more force than is necessary is used, and if it's proportionate to the seriousness of the circumstances. So that was the legal framework that the inquiry was looking at, and I've added references to the bottom of each slide so you can see where you can find this in the inquiry report. Moving on then to the approach taken by the inquiry to the use of force. Obviously, the inquiry was looking at Article 3 in this context. Similar points are relevant to the question of assault and battery, but specifically here, the inquiry was looking at case law in relation to Article 3. And this is as set out in the report. Deliberate humiliation and debasement of a victim is a factor that may be taken into account when considering degrading treatment, but such a purpose is not required in law to find a breach of Article 3. Case law has also established that the use of unnecessary force on a detained person can diminish human dignity and be contrary to Article 3, even where there has been no injury caused as a result, and that comes from Keenan and UK. What the chair did in making her factual findings was set out a list of questions that she was going to consider, and it says in the report that it's not a list of exhaustive questions, but these are some of the key questions. And in relation to the use of force, the key question identified is if physical force was used, was it strictly necessary? So we come back to the same thing that's in the rules, and the same thing that's in the prison service order, and so on. On each occasion when force is used, consideration should be given to whether it's necessary and proportionate in the circumstances. So looking at the reasons that were recorded for the use of force. So in terms of the relevant period that the inquiry was looking at, the 1st of April 2017 to the 31st of August 2017, In terms of the use of force reports, and separately there's an issue about whether a use of force report was always created, but in relation to the use of force reports that were created, there are 109 use of force incidents for which there was a use of force report during that relevant period. And the majority of the uses of force were recorded as unplanned or spontaneous or responsive incidents. And the reasons given included the prevention of self-harm or assault or for the personal safety of officers. However, the most common reason recorded was to maintain good order and discipline. Now, thinking back to the detention centre rules and what is set out there, just by way of reminder, so the centre will ensure that force is used only when necessary to keep a detainee in custody, to prevent violence, to prevent destruction of the property of the removal or of others, or to prevent detainees from seeking to prevent their own removal physically or physically interfering with the lawful removal of another detainee. You can see there that to maintain good order and discipline, which is really language that comes from a prison context, is not one of the justifications under the detention centre rules for the use of force. The chair then identified a number of concerning themes that came out of the uses of force, and force used to provoke or punish was identified, and the example which you may have heard about, I expect you will have heard about already today, D1527, and the chair said, I consider that DCO Jan Pascali deliberately and with intention to provoke and punish D1527 for what Mr. Pascali considered poor behaviour, placed his hands around D1527's neck while threatening to harm him. So it will be noted that this is contrary to Rule 41, specifically the second part, no officer shall act deliberately in a manner calculated to provoke a detained person. So already, if somebody has behaved in that manner, it's a breach. Another theme identified was the chair identified the use of an unauthorised technique, which was the handcuffing of detained people with their hands secured behind their back when seated. And that had been removed from the use of force training manual following the unlawful killing of Jimmy Mabenga. Despite it having been removed from the training manual, and the chair found that this happened in 2016, the same technique was found to have been used against D1234, D1914, D149 and D2054 during incidents between the 28th of March 2017 and the 28th of June 2017. So you can see that if you have a case where somebody has had this technique, handcuffs applied to their rear and secured while seated, automatically you have a question about whether it's a necessary and proportionate use of force, given the state of knowledge that it's not an approved technique any longer. And the chair made a recommendation in relation to the use of an unauthorised technique, which was recommendation 14. And what she said was that the Home Office and contractors operating immigration removal centres must ensure that all staff are aware that the technique of handcuffing detained people with their hands behind their back while seated is not permitted, given its association with positional asphyxia. So again, the previous information that this was not an approved technique has been strengthened by this recommendation. So it's difficult to see how somebody could say we did not know that we weren't supposed to be doing this, because there is repeated guidance and now a recommendation that this should not be adopted. In terms of further concerning themes, the chair identified staff incompetence. And what she said was, in a number of use of force incidents, staff struggled with basic techniques. And she also said that at times staff used authorised techniques that became dangerous due to their incompetent application. And the chair identified that there were a number of instances of use of force where it was not being used as a last resort. So again, going back to the statutory framework and the policy framework, use of force shouldn't be used as a first resort. It should be a last resort. And what the chair said was that there was considerable evidence that during many incidents, officers were too quick to employ force. Indeed, force was used on these occasions as a first resort rather than a last resort. During the relevant period, de-escalation techniques were either not used at all or were not used for long enough. And it appears even at DCM level, there was a lack of understanding of how to de-escalate a situation and explore all other reasonable options before using force. And in the same section of the report where the chair says this, there is a reference to an incident, and you've already heard Mark mention D687, and there is reference to an incident of D687, which is part of the same incident we just saw in the clip. One of the other concerning themes that the chair identified was use of force against naked detained people. And she said that force was used inappropriately against naked detained people, and said that it is important that there are guidelines in place to protect the dignity of detained people in these circumstances. She said it is clear that a strategy did not exist which resulted in what may otherwise have been unproblematic use of force incidents becoming humiliating for the detained person. So in other words, there may be an example where the use of force in and of itself might not be considered to cross the threshold for a breach of Article 3. But because of the circumstances and the fact that force is being used against somebody who is naked at the time, that increases the humiliation of the circumstances and makes it more likely that it will be inhuman and degrading, even if the use of force is more minor compared to other uses of force. And another concerning theme, which I said I would come back to, is the inappropriate application of a prison service order. And the issues that I've just discussed, the chair said demonstrate that the application of the use of force PSO to govern the use of force inside immigration removal centres is inappropriate. Immigration removal centres have a different purpose to prisons and a different type of population, and so different types of issue arise. It may be that Dr. Patterson wants to pick up on this shortly. So just in terms of conclusion, given that this conference is about how we can use the findings in the Brook House Inquiry report in other cases. So the first thing that we can take from the report is that it demonstrates the sheer prevalence of use of force incidents in immigration detention. And that means, or it should mean, that when people come forward and say that they have experienced an incident, a use of force incident whilst detained, that there is a background of just how much of this is going on. So already it should enhance the credibility of clients when they come forward and say, I've been assaulted while I was in detention. Secondly, it provides a useful framework for looking at use of force incidents within the context of immigration detention claims, both in terms of the Human Rights Act 1998 and Article 3, as well as claims in assault and battery. So in each case, if the use of force is not reasonable, necessary and proportionate, then you should have a claim that could be pursued. Thank you for listening.
Thank you, Una. And I think we're just going to go straight on to Dr. Patterson. Can you hear us?
I can. Can you hear me?
We can. Take it away.
Good. Thank you very much for the opportunity to speak at this event, and my apologies for being unable to join you. Unfortunately, I'm getting a flight very early in the morning from Edinburgh, and there was really no way to make the logistics work. What I'm going to do is talk probably in somewhat broad terms about the issues around mental health and the use of force, and then talk specifically around probably the main area of contention in this case and in relation to immigration and detention, which was the use of pain and the use of pain with people who were diagnosed with mental health issues. Context. The use of force in mental health is always contentious. It's long been contentious. There are debates going back to the 1800s about the appropriateness of coercion or otherwise. Momentarily, we are within mental health very much concerned with understanding, recognition and response to trauma, and the abiding principles that inform practice and therefore inform the use of force and therefore inform discussions around the use of restraint and therefore discussions of the use of pain is this notion of trauma-informed, and is our practice trauma-informed? And the series of principles describe what's called trauma-informed practice. These include recognition, realization, response. How do we recognize trauma in the population? How do we respond to that trauma? What do we do about it? And one of the key principles is that we should be working hard to avoid re-traumatization. And in thinking about avoiding re-traumatization, what we're mindful of is that any scenario which recreates elements of previous abuse, including abuse in the context of inequalities of power, is likely to cause re-traumatization. The inappropriate use of force is likely to cause trauma, but the inappropriate use of force with people who have previously experienced that and may have experienced on multiple occasions is particularly likely to cause trauma and particularly likely to cause further re-traumatization. When we talk about the use of force, that includes physical force. That also includes, for example, in other contexts, the use of compulsory medication. It includes locked doors, it includes seclusion. In this particular instance, I'm going to focus on pain. I'm going to focus on pain compliance because that was really the key issue of contention in this particular setting. Now, pain compliance is contentious in mental health, and it's been contentious in mental health in the UK. Certainly for the last 30, 40 years, there's been a real reawakening to the issues around this. And partly that came from the unfortunate experiment in which mental health services largely adopted control and restraint without really thinking through the implications of that. And it's taken about 20, 30 years to recover from that particular blind alley and all the problems that went along with that. So if we're thinking about the use of force, as previous speakers eloquently summarised, we need to be able to demonstrate the use of force is reasonable and proportionate. Those principles apply to the use of pain. And in using pain to gain compliance, what we are doing is saying to staff, you can use the deliberate application of pain, you can hold the patient, you can hold the individual in such a way that you can use pain, typically by pressure across a joint, and the aim of using pain in that context is to gain the patient, is to gain the individual's compliance. Now, there's been a very significant move away from using pain in mental health, and effectively it's banned in routine usage across the mental health estate. It is allowed in certain emergency situations where there is immediate life-threatening behaviour, but apart from that very specific and restricted set of circumstances, there isn't effectively a ban. Now, it's banned because there's a series of assumptions which underlie the use of pain compliance are very problematic when we come to think about its use in relation to mental health. So first of all, we have a significant number of inpatients who have experienced significant pre-existing trauma. We have, by definition, a number of individuals who are behaving in ways which are irrational at a particular point in time, leading to their admission. We have a significant proportion of the population whose cognition and cognitive judgments are impaired. Now, pain compliance assumes that I tell you that I'm going to use pain unless you comply. You can process that information, you can process the language, you can understand the language, and you can make an association between your actions and the reaction in terms of pain. Now, that's problematic for people who've experienced severe trauma, because under a relatively low level of stress, these individuals may tip into kind of full-blown fight-flight in which their ability to process information is limited. These individuals may experience flashbacks triggered by the use of pain, and that evokes a scenario where they're no longer struggling against the use of pain in this situation, they're struggling against the use of pain in a previous situation. And we also see significant levels of dissociation in individuals exposed to significant trauma, with these individuals again under relatively low levels of stress dissociate. What that means is this individual is unable potentially to process the information needed in order to make that judgment. So we're applying pain to a situation, assuming the person will react rationally when irrationality may be one of the key characteristics of the situation and key characteristics of their presentation. We're also making a series of other assumptions which are equally problematic. We're assuming that the techniques by which staff are expected to apply pain can be graduated. Staff know when they're using pain and they know when they're not using pain. There's some good research that suggests people's pain thresholds vary significantly. The degree of movement, for example, in a wrist lock involved in pain, with one individual may cause severe pain and another may not cause pain. So there's no reliable way to staff to know whether in actual fact they are applying pain or not, which means they may be applying pain unintentionally, but certainly it's very likely they're going to be unlikely to apply it in the graduated way which underpins use of force. There are also long-standing problems in allowing the use of pain as a last resort in emergency situations. If staff attributions are that the behaviour they're dealing with is not to do with an underlying mental health condition, but is a function of the individual's character, as a function of bad choices, then by giving them the option of using pain compliance, you're giving them the option of using pain in order to induce compliance, and not only to induce compliance, but to punish the patient for their misdemeanour as staff perceive it to be. Historically, there were also beliefs that the use of pain caused no long-term harm. There's now very good research, several meta-analysis that says the use of restraint can cause harm. The use of pain restraint may be particularly associated with harm. One of the problems, of course, is the nature of the environment in which these techniques are being used. I was talking earlier about a shift to thinking about trauma-informed practice. And in thinking about trauma-informed practice, what we need to recognise, first of all, that many of the services in which pain might be used, in which restraint might be used, are themselves what's described in those just trauma organised. In essence, these services come to mirror some of the characteristics of people who they support. They become highly reactive, they become hyper stressed, they become crisis driven, thinking gets fragmented, high levels of conflict are not dealt with, they become overt. Over time, these organisations have a tendency to become controlling and fundamentally to become driven by fear. In essence, they end up mirroring the pathology of the service user population. This becomes hugely problematic because what it leads to is a deeply corrupted culture. And certainly in my view, and I note that the inquiry chair concluded, there's good evidence that services that support individuals who are detained are very prone to become corrupted, and certainly in this instance, I would argue, became corrupted. Now, what we need in order to address the underlying misuse of force, which is endemic in many settings, is this very much move towards a kind of trauma-informed practice. And trauma-informed practice is about understanding why the background to many of the people who are being served, and also the background to a significant extent of many people who are providing the service. There's a literature around what's described as a high ACE, low-wage workforce. That recognition of the implications of working in these particular settings at these particular times over time. So the services need to be trauma-informed. Actually, ideally, what we need to do is to be looking to create services fundamentally which are therapeutic, which may well be custodial, may well have a custodial element in terms of what they're trying to do, but what they do is provide a space that enables reflective practice by practitioners, by managers, by staff, which understands the impact of working with individuals who have experienced trauma, which looks at different ways of making meaning out of this behaviour that people see, that thinks about conflict as being a positive strategy, and that fundamentally comes from a place of kind of compassionate leadership. We saw almost none of that in Brook House. We saw an organisation which did not understand the processes that ultimately came to manage it. We saw a failure to reflect, we saw a failure to learn, we saw significant evidence of authoritarian practice, we saw an increasing emphasis on control, and those drove the misuse of pain. Pain provided the means to exercise the processes which led to the organisation itself becoming trauma organised. Okay, what I've done is give you a kind of quick overview of some of the kind of key issues that come into play in terms of what we're trying to do. I would be delighted, of course, to take any questions.
Thank you, Dr. Patterson. We'll take questions, I think, at the end. So if you can, if you've thought of something, write it down, or if you're better than me, keep it in your brain. And we'll come to it in a bit. But next, we're going to move on to Nick Armstrong, who is going to talk about a few things.
Thank you, Mark. Can I just check I can be heard okay?
Yeah.
Okay, thank you. I'll do some kind of introductory remarks and then I'll talk about the thing that I think I'm meant to be talking about, but I'm going to do that briefly. The point is with the Brook House report and the Brook House process is that when you get into the detail, and when we all got into the detail via the inquiry, you see in glorious technicolor just how awful immigration detention is and certainly can be in many respects. It's that detail that shows it in true awfulness. But the real point about this is in that many of and most of the fora in which we operate, the judges, the decision makers, the policy makers don't usually see that. And they don't usually have the benefit of days and days of oral evidence under close examination by senior counsel. They don't usually see any oral evidence at all. And so in judicial review, as you'll know, is a mostly documentary process. The immigration tribunal is a mostly documentary process. To the extent that there are witnesses, they tend to be from our side and not from the Home Office side. So they never see it and they never have it tested and they never see the people who operate these systems up close and personal. You see glimpses and you see it. You see that in inquests, which remain a gloriously oral process, but beyond that, it is only through something like Brook House inquiry that you really see the depth of the awfulness. And of course, we'd never seen it before because it's the first public inquiry that had ever occurred in this area. So what the inquiry has done, and it is a good report, we were all very concerned as to whether or not we would get this, but we have in the end. Kate Eves has done us proud, not got quite as far as we might have gone, but it has definitely done a good job and a thorough job. And what that has done is kick open the door a little bit, and we all need to allow that door to remain open and not sort of, to mix my metaphors, sink below the waves, not let the water close over it. Because she has done what she's meant to do, which is an Article 2 and 3 effective Article 2 and 3 compliant investigation. Now, what you have done, I think, is spend a day with all of us talking about different bits of the inquiry and stuff you can use. So you will have heard about Rule 35, you will have heard about what is essentially as close as the chair could get to a finding of a systems breach for Article 3 in the language that she used. The Inquiries Act prohibits her from going any further, but the language that she uses clearly shows that there is a systems breach because Rule 35 is not working. You've heard the use of force repeated again by Una and Dr. Patterson just now as to how bad the use of force gets. The misuse of segregation for those with mental health and to comply, to seek compliance for those with mental health, to punish those often with mental health problems, and to punish behaviour that might be related to mental health problems, and to, in case I've seen recently, I'll talk about again in a moment, to secure compliance with medication for somebody with mental health. Not, you will notice, seeking to use the Mental Health Act, which is the route that you should use in order to medicate or treat somebody, not even using the Mental Capacity Act, but to use Rule 40 segregation. I'll come back to that in a moment. And then that's before you get on to all of the culture, the language stuff, the management void that allowed all of these things to exist. Now, all of those sections of the report can be set out in detailed grounds in judicial review in order to demonstrate to judges, look, this is, you are not seeing this directly, but this is how bad it can be. And we are using this as a recent report to bring to your attention the seriousness of what our client is describing. And you can use it in all of those different contexts. So you should all become familiar with the report and be ready to set out the relevant paragraphs in your grounds where relevant. In addition, can I also just flag, in case nobody else has made this point, there are times where you might be looking at materials in your judicial reviews or your civil claims or whatever else, where you begin to recognise names or should be recognising names from the witness list at the inquiry. So I'll talk about this again in a moment, but part of the case that I was arguing with Lewis and Alex Schmidt last week was about the activities of people including Steve Skitt, who was doing things in relation to Rule 40 in late 2022, only a few short months after he could not have been under any illusion as to the appropriateness of what he was signing off, given the evidence that he had given and the challenges that he received during the course of the inquiry. And those are things that you might want to point out, and we certainly did point out in the grounds that we were drafting. Keep those things in mind, because it is something that happens in this context. A few years ago, I was acting in an inquest and a civil claim, both relating to Harmondsworth, where a very senior member of the detention operations of the defendant felt able to give evidence in a civil trial, sign off a witness statement for civil proceedings, signed off with a statement of truth, describing the sufficiency and adequacy of the medical record and treatment process at Harmondsworth. And when you looked in detail at what she felt able to say, it was difficult to reconcile with the evidence that she had given and heard at an inquest the day before she signed the witness statement. Now, the only reason the only reason why anybody ever spotted that was because there happened to be, it happened to be me who'd asked the question the day before when she was giving evidence in the inquest. She had gone home from the inquest and written a statement of truth and an account of how reliable all these systems were the following day. That is an astonishing thing, and it just makes one think about, if you are going to do awful things to people a lot of the time, you tend to pull a bit of blindness over it in order to allow yourself to continue. And sometimes that blindness can spread a little, and you may simply not want to know or realise what you are describing, and you simply close your mind to what you are seeing, and occasionally what you are writing, including in witness statements. So keep yourselves aware, keep an eye on the date on which these things occur, and also keep an eye for a while on the dates on which certain individuals gave evidence before the Brook House inquiry. But there are also other things about this, because it's clear from the end of the inquiry report, you'll see all of this material, that the chair was clear that so far as she could see, these problems had not been fixed. The evidence that we look at, for example, Dr. Uzerali, towards the end of the inquiry, Dr. Uzerali, the GP, was PPG, now the healthcare provider, were failing to correct and could not correct what they at the time thought were clear failures, in particular in relation to Rule 35.2 reports. And as I understand it, Dr. Uzerali remains there. Many of the staff remain there. But the case that I was mentioning, I mean, all of you, I assume, continue to do cases that involve Brook House, and on a day-to-day basis are having reported to you many of the same problems that were occurring in 2017 and which the chair thought was still happening in 2022. It is not getting better, and it is unlikely to get better given the projected growth in the detention estate as a result of things like the Illegal Migration Act. There was, as some of you in the room may know, and I know that Mark knows, I think a couple of weeks ago, there was a death in relation to Brook House, in Brook House. Now, it's always amazed me that there hadn't been a Brook House death before then. There is an inquest that will now take place, obviously, as a result of that. I will just say that the coroner is going to need, whoever ends up doing that case, the coroner is going to need help with understanding not only the immigration detention systems in place, because the jurisdiction in which Brook House sits is not a case that has any other immigration removal centres in it, or indeed many prisons in it. So understanding these systems properly is something with which the coroner will need help. But the coroner will no doubt also need help with lots of detailed issues around evidence. It'll be evidentially relevant what's happened in the Brook House inquiry only a few months before this death occurred. So just keep an eye out for that case, anybody who ends up acting in it, because that is another case where we will need to tie things together and make sure that a full picture is presented in order to understand whether the picture has changed since we were doing all of this work on the inquiry. And just to fill in a feature, you may have heard about this case from others, from Alex or Lewis earlier in the day, and I apologise if so. The case that we were arguing last week and was listed for 3 days but settled at the end of day 1 was a case about the evacuation of everybody out of Harmondsworth in November 22. November, Harmersworth basically collapsed as a result of a power outage that was eminently avoidable and well understood, and you know, there were plenty of warnings, particularly in the summer of last year, that something like that might well happen. But there was a spectacular and striking lack of planning should such an eventuality occur, particularly a lack of planning in relation to those who had mental health problems or otherwise vulnerable or had particular kinds of medication, including antiretroviral medication, the kind of thing that can't be interrupted. No thought about any of that at all. Just carry on anyway. And then on top of that, when you, of course, have to shift 500 men around the immigration detention estate at speed, one of the places in which you are likely to arrive is Brook House. Now, if you are presenting this on the basis that Brook House and Rule 34 and Rule 35 are likely to be able to pick up any difficulties that you've had through a lack of planning, not if they're in a systems breach, not if their systems are such that they may be breaching the systems duty under Article 3, and consistently with all of that, we saw in relation to the two clients that we were acting for last week, you see the usual and expected spectacular spectacular breaches that you would expect to occur, including in relation to the HIV positive client, who had the added element that the Home Office had already been sued in relation to HIV. See the case of CSM and then the case of LC, and they knew that they had to keep an eye on people with antiretroviral medication. They had amended badly. They had done the minimum policy. They had done the minimum possible. They had amended the AAR, the Adults at Risk policy, on the 1st of November 22, and then the evacuations occur 3-4 days later on the 5th of November 2022. And yet still they managed to go through that system and carry out no checks, no reviews. And obviously, as a result, this man misses several days of medication, where 95% compliance with the medication is obviously critical. Now, I'm being the joys of virtual things means I can get warnings from Steph telling me to speed up. So I will. The point I just want to make about all of that is that experience too confirms that Brook House is no better, and confirms that steps need to be taken in relation to correcting that. Can I also just make the point about this? That is a case which also showed, like Brook House shows, there is a failure of investigation and a failure to learn and a failure to confront the consequences of the actions, which leads to a further breach of Article 3 in relation to that, and also a breach of things like the public sector equality duty. So these investigative duty cases occur across the estate in a variety of circumstances, and I just ask you quickly to bear that in mind. Now, the thing I do need to mention, I'll do it in one line. Section D10 of the report is about the complaints process and is another thing that you can plead in relation to making good the points if that arises in one of your cases. It unsurprisingly finds that the complaint system is hopeless. It didn't work. They have untrained staff that do not look for evidence that supports the detainee, and they only look for staff material that will undermine the detainee. They look as likely as possible. They don't have the material. Body-worn camera footage disappears, isn't kept. There's always an IT problem. Oh, whoops, it wasn't uploaded, all of the rest of it. Those missing records mean of themselves that there will be a breach of the investigative duty, because it means that an effective investigation took place because the evidence has disappeared. Look for all of that material. Keep in mind also the original judicial review in this case, the MA and BB case which produced the inquiry in the first place, and the specific holding that says one of the things that an investigation must do, or will often do depending on the circumstances, is require those who have been the victim of this kind of abuse to confront those people who have abused them. Now, that's a very big finding, and it's the reason why the Secretary of State sought to appeal and was knocked back by Lord Justice Bean on that point. So that remains well-established law, keeps that in mind. But it comes down to this. We did kick open, all of those involved in this did, we did a lot of great work, and the inquiry team, the counsel to the inquiry team and solicitor inquiry team did great work. They kicked the door open a bit. Keep that door open. Get out there, do good, and do not, the light was shone for a little bit. Do not let it dim too fast, and also please find new lights to shine, because it is at least as bad as you thought it was, and it continues to be at least as bad as you thought it was. So it needs to be investigated, it needs to be called out, it needs to be confronted, and an explanation needs to be demanded and provided. I'm very happy to deal with questions too, if there's any time left. Sorry, Steph.
Thank you, Nick. I think we've got about 6 minutes left for questions and answers. I think as a starting point, I would just say that having sat through what you've sat through today, it's a bit overwhelming and there's a lot to absorb. But by now you will have understood that there are a lot of, an innumerable amount of issues at Brook House across the immigration detention estate, because these are systemic issues. What you may also be seeing now is how these issues are connected, how they thread together, and a failure at the outset of detention can culminate in really serious consequences. For example, where there's been a failure to safeguard an individual, vulnerable person has been detained unnecessarily, and then the vulnerable person has had unlawful misuse of force on them. The impact is so extreme. These things thread together, and that's what I would encourage people to look at. Questions? Anybody? Hands up.
Sorry, I had a question regarding the issues around G4S officers not properly applying the correct legal tests in the 2001 rules, so perhaps more answerable by Una. There's a point in the inquiry where they talk about procurement. They talk about the failures around the bids to deal with the services in Brook. They were particularly in the context of detainees' welfare. If they'd ran a diligent procurement process and properly vetted the providers that were bidding for these contracts, do you think that could have mitigated any of the issue?
I'll say one thing, pass it on to Una, and then Nick might have something to say about this. There is an admission by Mr. Phil Riley, who was head of detention escort services, in the course of his oral evidence to the inquiry, that if they had properly monitored the contract performance at Brook House, then none of this abuse would have happened. So, that I think that's a really stark and extreme example, privatisation and improper monitoring. But let's not let the buck get away from the Home Office. It is them; it's their responsibility.
Yeah, I think you have to look at the culture. In some ways, is informed by how the service is run. So there is that, but that's not the end of it. The culture exists because of the wider structures, and the fact that the environment itself, the fact that this is essentially a prison, but is being used for immigration detention. So all of those different factors feed in and create the culture. The way in which the contract is set up is just one part of that. So would I like to say everything would have been fine? I doubt it very much. The instances of the use of force, really the rules are there, the law and the framework is there, but it was still being breached with impunity. And would that have stopped just because the contract was set up in a different way, or because it wasn't privatised? I don't know.
Nick, and then Dr. Patterson, if you have anything down at the end, we'll go on to you. But yeah, Nick.
I mean, I'd be amazed if any recruitment exercise could achieve anything much different to what we saw. If you are going to recruit people at this level, with this lack of training, with this lack of salary, in this hostile environment, with the language used by these political leaders, then you are likely to see something along the lines of what you saw. And we did see that. And the only way you could avoid that would be with a quality of leadership within centres that is far from likely on the ground, I'm afraid. So I would be in a position of significant pessimism about any of this changing. I did see, by the way, one of the things that you do if you cross over between prison law and immigration detention is that There's really struggling to recruit in the prison service at the moment, because one of the things that prison officers really don't like, so if you've got 25-year-olds coming into work in a detention centre, they hate the fact that in prison they lose access to their phones. So those people will actually much more, they'd much prefer to work in the immigration detention environment. Make of that what you will.
Alison.
I'm going to be slightly contentious, I think, in suggesting that we need to be optimistic about the possibility for change. Having worked in mental health for some decades and seen positive changes, I think positive change is possible. I think the problem in relation to Brook House was not just the Brook House became a corrupted culture, but arguably the whole immigration and detention estate, and that came from the top in terms of the messages and the dehumanization and the culture of disbelief that was propagated. I also think some of the decisions in terms of privatisation, my understanding is the Home Office insisted that G4S use the prison service system, which at that point did not have a graduated hierarchy of techniques. So it's the expectation you can use other than pain compliance in a situation, but you're not trained in any techniques other than pain compliance. As the old adage goes, if you have a hammer, everything ends up looking like a nail. So there were some very specific things that could have been altered. And on balance, I think we have reasons to be optimistic. However, that required really significant change. And leadership from the top of the organisation and really from the Home Secretary.
Thank you, Dr. Patterson. So we are at the time limit that I have strict instructions to stick to. Unless I see any hands up very fast, I would suggest that we, if you do have any other follow-up questions, people are going to be around having a drink and chat, come up to us, ask questions, talk, share information. But a big thank you to everyone. Thank you to all our speakers, Una Morris, Dr. Brodie Patterson, and Nick Armstrong. And I think there's going to be maybe a brief
break.
We go straight on to a conversation with Stephanie Harrison, KC, and Professor Bosworth. Thanks.
Thank you very much. So I know there's a temptation because we've got very close to the end of the day for people to leave, but I really ask you not to do so. We're a shorter session than the rest. It's half an hour. It's going to follow on very much from where we've just left off, looking at the really important question of institutional culture. And we have the benefit of having the inquiry's own expert, Professor Bosworth, who works at runs the Oxford University Centre for Criminology. She'll give you a little insight into what she does, and then I will ask her some questions. This is your opportunity also to be more interactive. We don't have slides. So whatever questions you've got a real expert here, and we can deal with this in a more interactive way. But so it's intended to be conversational. That's how we'll do it. And obviously, I'll start off by saying, Professor Bosworth, thank you very much for coming. We understand the trains have made it difficult for your amount of time that you've got here with us, but we're really grateful that you have come. Maybe just to give people an idea of the work that you're doing in Oxford, because it is really important in monitoring and researching the big picture about what's going on. Maybe you could tell us a little bit about that first of all.
Okay. Thanks, Stephanie, and thanks for inviting me to talk. So I'm based at the Centre for Criminology in Oxford, and since 2009, I've been doing research inside immigration detention centres in the UK. I also have done some comparative work in detention sites in Greece as well. I say I've been doing it since 2009. In fact, since I was appointed to be the expert on the Brook House inquiry, it was made clear to me that I was no longer able to do research inside immigration detention centres in the UK. So I haven't been into one for the purpose of my own independent research since September 2019. Instead, what I've done is I've done a separate project, which is in the process of coming out in various publications now, which is on the short-term holding facilities and deportation. Quite why that was allowed and that IRCs was not allowed is unclear to me. But I basically do empirical research. It's mainly qualitative. It involves a lot of hanging around and chatting to people, observing things. following staff through their everyday activities, talking to people who are detained. Inevitably, in order to get research access, I have to produce things for the Home Office and also for the private contractors, which is not an unreasonable request on their behalf. So they like material that comes in Excel. So there is always a survey that I produce and that I then distribute. So I've created something called the Measure of the Quality of Life in Detention. Basically asks people in detention how they're feeling about a whole series of parameters. There's a version for officers. I've done a similar version actually for the staff who put people on planes and run short-term holding facilities. So I do mixed methods, but my real work is ethnographic conversations.
Thank you. And you had a role already in terms of the reviews that had taken place before the inquiry, because you did a literature review for the Shaw Review in 2016, and we know that that was a led to significant change, well, on the face of it, significant change with the adults at risk policy. But in terms of the significance of that review that you did, what did it show about immigration detention?
I just showed, I mean, I think one of the immensely frustrating things about immigration detention, which obviously the previous speakers also made clear, is that there's no lack of evidence, and we sort of are going round and around in circles to a large extent. And so the Shaw Review was an opportunity to put in writing once again what we already know, which is that immigration detention has a significantly disadvantageous effect on people's mental health, and that the negative effect lasts long beyond detention, the period of detention ends, and that the negative effect is more pronounced in certain populations, all the obvious ones that you would think of: children, people who have suffered torture, people who have sought asylum, the elderly. And so it was really, I felt at times that literature review, I was kind of teaching how people how to suck eggs, because anybody who works in the area knows all of these things. But what it was able to do was really pull it together and show by comparing studies that have been done in the UK, but also in other jurisdictions, that this is a kind of entrenched problem with this particular form of custody, and that there is ample evidence from multidisciplinary studies of that ill effect on people's mental health.
Sure. And so then when it comes to you being asked to become one of the three experts for the inquiry, and and your focus was institutional culture, and we've heard some of it in terms of what kind of culture was there. Obviously, high levels of use of force, misuse of force, leading to extreme assaults on individuals. We've heard about Dr. Brodie Passon describing a corrupted culture. And we've seen how that's in the context of a number of widespread, long-standing systemic failures in detention safeguard. So that's where we've got to now. And I don't know if you could just identify the factors that you saw as being the key components of this institutional culture that you were asked to look at.
So it's difficult. I should say this very quickly, shouldn't I? It's difficult because one of the things about Brook House is that Brook House has always occupied a particular position within the detention estate. So I mean, I can talk about what I saw in all the footage and all the material I was given to read, but all of that I looked at through the lens of somebody who'd been doing research in these places since 2009 and who'd done research in Brook House. I mean, I'd been in Brook House in 2019, for example. And Brook House has always been one of those centres that when you're in another one and you ask somebody who's detained, where have you been and, what was it like? They always say, oh God, Brook House was the worst. Brook House and Harmondsworth, they're the two that everybody hates. And when I first did my very first piece of research in these centres, one of the slightly controversial things I do actually when I do research is I carry keys. That's the only way I can get around without having an officer with me all the time. This was the only institution where I decided I didn't want to carry keys, that actually as a researcher I felt unsafe in Brook House, and that was in 2011. So Brook House has always been an institution that has had a reputation of violence, of disorder, and of problems. And so when I saw the footage or when I read all of the material, part of me was thinking, oh yeah, okay, it's Brook House. Like this is what this place is like. Everybody who knows about IRCs knows that the Brook House is one of the worst ones. The issues that were pronounced in the material that I looked at, I mean, some of them, I was saying this to you the other day, Stephanie, some of them are about Brook House specifically. and specifically perhaps at that historical moment. So I think it is important to reflect on the way the footage showed this very shockingly high level of availability of psychoactive substances that were in the detention centre. So the kind of basic requirement of security had been breached, and that the centre was not a secure environment for anybody because drugs were coming in. And that, that is actually not, or it didn't used to be that common. So that was unusual, I think, and that perhaps was specific to Brook House at the time. But then other things, you find in other places. So the layout, the design, the staffing, the lack of staffing, the sort of the racist stereotypes that are used about certain populations over other populations. So the tendency always to think that the young black men are aggressive and to be, very aggressive back to them or to them in the first instance, versus the sort of condescension about how officers quite often talk about Asian prisoners, detainees, all of that. You go into any detention centre and you'd see that. And you see that in many detention centres in how they house people. So Harmondsworth has got different kinds of housing units, and they put different nationalities in them. Morton Hall, when it was open, did exactly the same. And then lo and behold, the sections where they have more of the black detainees, they're the ones which are always considered by the staff to be more problematic, more dangerous, more disorderly, less compliant, all of the words that they use. So there were bits of Brook House that were just detention as usual.